Semifinals of the 5th Surana and Surana and CUSAT Dr. A.T. Markose Technology Law Moot Court Competition 2025. Thank you, judges, for being here with us. For your kind attention, we have here Team Code 07 representing the petitioner, the Society of Medical Ethics, and Team Code 15 representing the respondents, Sumantra Hospital and Research Center. Speaker 1 for the counsel for the petitioner, TL07, we have Akansha Saha, and she will be speaking for duration of 14 minutes. And speaker 2 is Murali Karthik, and he will be speaking for 29 minutes, reserving 2 minutes for rebuttal. Speaker 1 for the council for the respondent TL15 shall be speaking for 25 minutes, and speaker 2 will be speaking for 16 minutes and reserving 4 minutes for the rebuttal. With the permission of the judges, I invite speaker 1 from the petitioner's side to present their arguments.
The counsel for the petitioner seek permission to approach the dais and collectively address the benches, your lordships. Much obliged. Your lordships, if it may please this honorable court, this is the counsel for the petitioners appearing in the case of Miss Y and another versus Sumantra Hospital and Research Center. Your lordships, can the counsel proceed with the statement of jurisdiction?
Yes.
Much obliged. Your lordships, the petitioners stand before you today under Article 226 of the Constitution of Samrat, seeking for the writ jurisdiction. If your lordships are satisfied with the statement of jurisdiction, can the council proceed with the arguments, or would the uh, can I come up with a short version of the facts of the case?
You can move on to the arguments.
Indeed, your lordships. Your lordships, as counsel one, I will be dealing with the first and second issues, and my co-counsel will be dealing with the third, fourth, and fifth issues. So, starting off with the first issue, your lordships, whether Miss Y can demand termination of pregnancy under the provisions of the MTP Act. Your lordships, the councils humbly contend in three perspectives that we can. Your lordships, the first contention will be the interpretation of the MTP Act. Three types of interpretation can be used to interpret this act. The first way would be the purpose of interpretation of the MTP Act. Your lordships, I would like to rely upon the judgment in X versus Principal Secretary, NCT of Delhi and another, where they have clearly observed and held that the purpose of the Medical Termination of Pregnancy Act is solely to safeguard the women's reproductive bodily autonomy. Your lordships, hence, forcing her into a motherhood in such a circumstance would only contravene with the objective or the purpose of the act. Following up with the same form of interpretation, Your Lordship, I would like to derive on the mischief rule of interpretation. Your Lordships, in the same case of X versus NCT of Delhi, it has again been reiterated that the purpose or object of an act is its mischief. Your Lordships, to draw a more conclusive argument, I would like to tell what the mischief in the case is. Your Lordships, the MTP Act was established in the first place to provide females with legal termination of pregnancies by registered medical practitioners, Your Lordship. Now, in the case of my client, Miss Y, she is seeking for the same. Because of no mistake of hers, shouldn't she be not taken of her right to seek for termination of pregnancy?
When you say that the purpose of the MTP Act is to protect the rights of the mother, can you say that that is the sole purpose of the Act, or is it also to protect the rights of the fetus?
Your Lordship, in response to this, I would like to say that the sole purpose of the act being makes it a beneficial legislation of the state, because we are a welfare state. They have made MTP Act a beneficial legislation only on the pretense of the mother. Your Lordship, this goes hand in hand with our case, which is in support of Miss Y, our client. If your Lordship is satisfied with that answer, can I make
Why
my
do you say that? Why do you say that the purpose or the intention behind the Act is to protect the rights of the mother? What is the basis for that statement?
Your Lordship, the objective or the short title of the MTP Act itself. If your Lordships have the MTP Act, I would like to
Yes.
direct you to the short title of it. Your Lordships, the short title states it is an act to provide for the termination of certain pregnancies by registered medical practitioners and for matters connected therewith or incidental thereto. Your
So
Lordships,
can I just if I can pause it at at
indeed,
that juncture? The
indeed.
entire issue, the objective itself, is that the termination can be resorted to only at certain instances. This is provided even in the objective. So this is a restrictive legislation rather than a legislation which gives a benefit to a person.
Your Lordship, in response to that, I would like to rely upon precedents because courts have regularly reiterated that the MTP Act is not restrictive in the parlance of a mother who is trying to terminate her child for various reasons. The reasons, be it if the child has fetal abnormalities or if the mother is going through a physical or mental health trauma. Your Lordship, it is a beneficial legislation as reiterated in X versus Principal Secretary and Suchita Srivastava. Both these judgments by the Supreme Court tell us again and again that it is in favor of the mother that we shall rule. Your Lordships, if this is convincing, can I proceed with my next submission? Much obliged. Your Lordship, stepping on to the next aspect, that is principle of legislative silence. Your Lordship, here I would like to dwell upon a legal maxim, lex semper, non quod convent ratione. Your Lordships, this simply converts into the law, always intends what is consistent with reason. Your Lordship, this I'm trying to draw parallel with our case where indeed we have a right, Your Lordship, but this is very constricted to the contemporary forms of legislation that should have been done, Your Lordship. For example, artificial womb technology that our client hasn't consented to is itself a very nascent and experimental technology. We don't have legislations to regulate or protect the same, which is why it wouldn't be of proper reasoning to take away this right from our client. Rather, we should be able to fill in this legislative silence. That is what is humbly contended, Your Lordship. Lordship, moving on to the second submission that I'd like to make is our client satisfies the grounds for termination of pregnancy under the MTP Act. I will be doing this in a fourfold manner, Your Lordship. The first fold the Council would like to submit is the length of the pregnancy, Your Lordship. If Your Lordship is referring to where I'm getting this from, it would be Section 3 of the MTP Act, Your Lordship. Under this section, it has been elaborately mentioned that anybody can terminate their pregnancy if it is under 20 weeks. And Your Lordship, our client Miss Y is falling well within the ambit of 18 weeks, Your Lordship, hence checking the ground for 20 weeks. Your Lordship, moving on to the second ground, which would be grave injury to mental health. Your Lordship, this the Council shall argue in two folds. First, as to how there is mental health will be addressed in reliance to the ex versus Principal Secretary of State case, Your Lordship. Here, it has been said that an unwanted pregnancy can be construed as injury to mental health. This was what was held, Your Lordship. So, in this case, they accept that if the mother is not willing to keep her child,
Was the pregnancy of 18 weeks even at the time when you requested for termination?
indeed, Your Lordship, in fact, the facts of the case do not have a chronology of events, which is why we assume that immediately the case was filed. That is what is humbly
No, but
submitted.
it says that while she was during her 18th week of pregnancy, she had a fall.
In,
Thereafter, she was taken. She was taken to the hospital. The child was taken. The fetus was taken out. All those things happened. So
indeed.
it's an assumption that it's still in the 18th week, right?
Your Lordship, I wouldn't say it's an assumption. I would say that because the facts of the case are silent on this pretense, the petitioners would like to use it to our benefit and say that indeed it was 18 weeks that we filed this case for, Your Lordship. If Your Lordship satisfied, may I
So
proceed?
what if it was? Let's assume for a moment that the pregnancy is more than 20 weeks old. What would be
Indeed.
the consequence then?
Your Lordship, then also there wouldn't be a major consequence because the petitioner would be able to substantiate as to how the child has a substantial risk if it were born. If Your Lordship would allow me to proceed to the next, which is my next submission, I would be able to conclude that. Your Lordship, the next submission, I would be able to conclude that. Your Lordship, the next submission is a substantial risk if the child were born. Why we say so, Your Lordship? It is humbly submitted that Section 3 clearly says that termination is permissible if a certain substantial risk is anticipated. So, Your Lordship, Drawing back to the facts, which is explicitly mentioned in para 8 of our proposition, we can see that the experimental procedure is still in its nascent stage, has not gotten approval from the Institutional Ethics Committee, which is a statutory body of the ICMR guidelines and Drugs and Cosmetic Acts itself, Your Lordship. Without proper approval, they have proceeded with the same, which is why our client Miss Y believes there is a substantial risk if the child were born, Your Lordship. Hence, we would try to omit such a situation from happening. I would like to draw
What if
parallel to
what if
this.
a medical board is directed to assess the condition of the child and the fetus, and whether the and also to determine whether there is any risk in the fetus being born alive?
Indeed, Your Lordships, multiple cases have actually established a medical board where they've evaluated the viability of the child. Your Lordship, now talking about the
So
viability of the
what you're submitting is only an apprehension. There has not actually been a study or a inspection or a medical inspection conducted by any particular medical
authority.
research center.
Indeed, not, Your Lordship. In the facts of the case, it hasn't been. Hence, I would like to draw parallel to the case of Mamta Verma versus Union of India. Your Lordship, this case has held that considering a situation where a mother has to see her child grow with substantial
Now, there
risk.
again, there might be reports suggesting that the fetus would suffer from substantial, any kind of issues because if it is born alive. In the absence of any such reports, how can you simply apprehend that there is a risk of fetal
Your
abnormalities?
Lordship, we wouldn't say this is an apprehension. We would say this has been understood from paragraph 8 of the fact sheet. Your Lordship, paragraph 8 of the fact sheet clearly talks about how this procedure is still in its developmental and experimental stage. Your Lordship,
Let's
since
assume for a moment that the fetus is not suffering from any abnormalities. And based on your apprehension or based on your concern regarding the nasal stage of this procedure, we terminate the pregnancy. Wouldn't that amount to killing of a per- perfectly healthy fetus?
to answer that question, Your Lordship, indeed not. In the case of X versus NC Delhi, Your Lordship, the same. It is pretty much mutatis
For a
mutandi
moment,
to our
let's
case. My opinion from the precedent, because in that case as well, they have held that there is no fetal abnormalities in X versus NCT of Delhi as well, Your Lordship. But the court again ruled in favor of the mother, saying bodily autonomy should prevail. The same is put forth here, Your
so then
Lordship.
given a go by to all the
Sorry, Your Lordship.
so the Supreme Court has given a go by to all the provisions of the
Indeed,
MPP Act.
not, Your Lordship, only in that particular pretense. The pretense being that there was a change in her marital status, which is why she was allowed to do the
What is the
same.
change in marital status? Just merely a divorce happening.
Indeed, not, Your Lordship. In fact, she's an unmarried woman who was promised that she would be married with. Hence, she gave conception to this pregnancy.
So
But
you're essentially
afterwards,
saying that
her
he was
husband.
subjected to rape under IPC.
Indeed, not, Your Lordship. We are not.
Rape on the promise of marriage.
But the court has again ruled in favor of the women, saying that even though
So let's assume for a moment that you decide to have a pregnancy while you are married to a particular person. After 4 weeks, you decide, okay, I'm not going to stay married to this person, or there are certain marital discords. Are you saying that that alone is a ground for terminating the pregnancy?
your lordship change in the marital status is indeed a ground for termination of pregnancy.
So now let's agree that you've moved on from the abnormalities argument, and now you've moved on to the next
Indeed.
argument.
It's that Rule 3BE, if your lordship's taking a look, it clearly states that a change in a marital status allows a woman to go forth with medical termination of pregnancy. Your lordship, this also preserves a woman's reproductive rights. Everywhere, the council is trying to contend that be it the MTP rules or the act or the precedents as well are ruling in favor of the beneficial legislation and supporting the mother. If your
Counsel,
lordship is
am I audible?
satisfied, indeed.
Yeah, counsel, I kind of get the entire view. You have been arguing
Indeed.
on the rules of interpretation, assuming the fact that MPP is actually favoring abortion, correct? Favoring the reproductive
Indeed.
autonomy of an individual, correct? So what if I tell
Indeed.
you that has been never the objective of MTP? If that was the objective, the nomenclature of the legislation would have been Abortion Act. It would have been much simpler for the layman to understand. It is Medical Termination of Pregnancy Act. So you can't abort within 20 weeks if it is not with the opinion of 24 to a registered medical practitioner. So what exactly are you saying? exactly is the objective of the legislation. So your entire arguments being based on this beneficial mischief rule of interpretation, I don't think that's going to actually work, because that is not just the rule of interpretation behind MTP. One thing. Second thing is, if you're causing the death of the baby inside the mother's womb, that could go uh, that could go towards abortion. Understood. But if you're causing the death of the baby outside the mother's womb, which is going to happen in this case, or if any part of the child has come out of the mother's womb, then that would come under explanation 3 to section 100, that is culpable homicide, specifically mentioned in BNS.
Your Lordship, can I take the time to answer this? Much obliged. Your Lordship, answering the question as to the fetus being outside the mother's womb, initially there was no consent given. And most importantly, Your Lordship, nowhere in the NPP Act has it been mentioned that the womb would be a natural or artificial womb. Hence, this does create a gray area for the judiciary to work on, which is where
Let's
legislators
apply
side.
the mischief rule of interpretation here. So
Indeed,
that
Your
would be to
Lordship,
protect the
listen.
fetus.
Your Lordship, I strongly believe that in Samrat, as of today, maternal mortality rates are still excessively high only because of illegal termination of pregnancy.
On law. Let's argue on law.
That was one statistic, and that being the mischief on which the purpose has can take safe medical termination of pregnancies. Now, the sole legislation that guarantees every single woman that you can terminate your pregnancy if you're willing to, or a circumstance appears as such, because of a contemporary change in the world, being a technological boom or a art revolution or a womb technology, can that right be taken away from our client? We humbly submit that that not be the case, and we ruled in favor of my client being a beneficial statute. It should be.
You're basically relying on the MTP Act, right? You're not relying on ART Act for sure, correct? Or is
No,
it both? Either MTP or ART or both? What's your stand?
Your Lordship, ART, I stated, because fall under the umbrella term of art, the art procedure.
Under ART, then we are talking about a commissioning couple, correct? By and large, you could have other persons also, single women as well, but by and large, commissioning couple, where you could withdraw the particular consent that's been given. But the terminologies are entirely different. Do you see the word child in the ART? You don't see the word child in the ART. You could see blastocyst, you could see embryo. That's fertilization up to 14 weeks.
Indeed, Your
18 weeks.
Indeed.
Could be anywhere between 18 and 24 according to the reply that you gave.
Indeed.
So we are out of ART right now. So please do not bring in ART arguments from now on. We are on MTP. It should be either MTP or all right.
Arguments. The next argument would be solely on the basis of my issue 2, that is whether the transfer of this fetus to this artificial womb technology that the client hasn't given informed consent for amounts to grave mental injury only on the basis of the MTP Act, Your Lordship. Starting off, I will give 5 major submissions, Your Lordship, to conclude this issue. The first submission I played is doctor's duty to informed consent wasn't complied with, Your Lordship. Your Lordship, even in the case of Samira Kori versus Dr. Manchanda, it has been stated that the court case of Canterbury versus Spence, and in this case, the reasonable prudent patient test was required the doctor. Your Lordship, in simple terms, the reasonable prudent patient test is nothing but the legal or moral obligation of a doctor to converse with their patient and let the patient know of the legal complications that are to arise and the
Canterbury versus Spencer. Was that Bolito or Balam being applied?
Sorry, Your Lordship?
Canterbury's case that you just mentioned.
Indeed.
In that case, was it Balam's test or Bolito's test that was applied?
Your Lordship, the council isn't aware of what the tests you have mentioned, but the test I am talking about here is the reasonable, prudent patient test, Your Lordship. And this test, in particular, talks about how there has to be an informed remedies available. Without the same, without letting my patient, without letting our client know about the risks involved or the other alternatives involved, it was quickly jumped into a conclusion because they stated it's a
Understood. If there is, see, Samira Kohli's case specifically mentions the fact that a procedure could be done without consent, and I quote, without consent, if there is an imminent danger to the life or health of the patient. Now, I can assume the second argument that we are not talking about any health hazards to the mother. We are talking only about the health hazards of the fetus. Correct. I saw that in the memorial as well.
Indeed.
Now, the point is this: if you talk about fetus having some sort of a health hazard. Correct? The fetus is going to die, which has been specifically said in the facts.
Indeed.
Don't you think that is actually going to be aggravating the death of the mother?
Your Lordship,
Which is a health hazard so far as the mother is concerned. Correct? So informed consent need
to answer that question of yours, we believe that informed consent from the patient needed necessary. But according to the facts of the case, her family was also prevailing
See,
with the
how
husband
can
at
how
that
can a
point.
person, either even the mother, so the
Not
doctor is both a doctor for both the mother as well as the fetus. Unless and until the doctor is a medical practitioner as contemplated under the Medical Termination of Pregnancy Act, his duty is to save both the lives, not just the life of the mother. So he'll have to do whatever is necessary to save even the life of the fetus. And now you're making good of the brave act done by the medical practitioner to say that you should terminate the pregnancy. Again, you're trying to kill off the baby.
to answer this question, Your Lordship, waiver of consent, assuming a situation where this were to happen, waiver of consent would only be applicable if the procedure they have transferred the fetus into was a tried and tested procedure, not something that is yet to get the permission of starting human trials for. Because this is yet to get permission, the least we're expecting from our respondents is they should have consulted, at least let be informed the family of the client is at least that we are proceeding with such a operation.
please give us an authority for the same that if not the husband, the next relative should be consulted for obtaining real consent or informed consent. Please give us an authority for that's the first question. Second question is you're focusing on ART, you focus on MTP, you focus on all these case laws, including Samira Kohli's case. You are talking about best interest of the patient, correct?
Indeed,
But
Your
the
Honor.
lady, when she was taken to the hospital, she was pregnant.
Indeed.
Correct. Hospital authorities, you can't assume them to kind of know about the paternity disputes and all those. So, what exactly, according to the doctors, would serve the best interest of the patient? Saving the fetus or not? Thank you.
Saving the fetus is the best interest as well as saving the life of the mother, Your Lordship. But
They
now,
didn't kill
since
her.
MPP Act,
They didn't kill her.
they didn't kill her,
They
Your
just
Lordship.
saved the fetus.
Indeed, Your Lordship. But also protecting her bodily autonomy when she's coming forward to seek for a termination and
Give the
blatantly.
authority. Give the authority. Please give us the authority. If not the wife's consent, if not the husband's consent, the next kin's consent.
She did not come seeking medical termination of pregnancy. She was unconscious when she was brought to the hospital.
Your Lordships, I would like to take precedence or I would like to draw parallel to Section 5 of the ICMR guidelines, ethics, Your Lordship. In Section 5, this completely talks about the informed consent process and how there is a procedure that can be gone through if the patient that is in bed is unconscious. Your Lordship, here it has been mentioned.
ICMR guidelines which one? 2017.
Indeed, Your Lordship.
That's on biomedical research and research involving human participants. That's not the question which I asked.
Your Lordship, but the case at hand is involving a procedure that is yet to get permission for human trials itself. And for the situation Your Lordship is suggesting, there is no stated or blatant regulation that we can follow, which is why the petitioners are relying upon the ICMR guidelines as given in the proposition as well, Your Lordship.
I understood that. Specifically says if not the husband, next kin. That I know, but I'm not talking about biomedical research here. That could be the next target. But yes, you may continue nevertheless.
Thank you so much, Your Lordship. So, in 5.1, Section 5.1 talks about the requisites in case the patient is unconscious. It says in the case of an individual who is not capable of giving voluntary informed consent, the consent of an LAR or a legal advisory can be taken. And here the LAR can be anticipated as the next of kin or anybody who is a surrogate in the moment who can answer for the patient itself, Your Lordship. That is what is humbly submitted.
This
If you
consent is required for what procedure? Human trial.
human trials, Your Lordship.
So,
To accept.
you think that the intention of the hospital was to conduct a human trial, or was it their intention after finding out, after consulting with the interventionist, embryologist, gynecologist, and fetal surgeons, that there is no other immediate medical intervention was necessary to save the fetus, and hence they had transferred the child through that procedure? So, would you say that they've opted for human trial?
Your Lordship, this isn't considered a human trial, but they also
Then it
haven't
will not apply.
gotten the permission for
So, the
human.
rule that you have read will not apply.
Your Lordship, I will explain as to why I'm drawing parallel to the same. because human trial they haven't been given permission to conduct human trials, your lordship. The institutional ethics committee hasn't given their approval yet. It's still pending. But
See, you
even
are
in
under
the
Article
case,
226 of the Constitution of India. You can either enforce fundamental rights or statutory rights. Can you show me any statutory right whereby you are required to give consent for whatever has happened in this case? Any statutory right? Even the ICMR guidelines, would that have any statutory force? I don't think so. So then
it
what is the
does, your
statutory
lordship,
right that
because
you're trying to enforce?
your lordship, the Indian Medical Association is the authority under which the ICMR guidelines have actually come forward.
You file a complaint before the Indian Medical Association in that case. How can a writ jurisdiction be invoked? Seeking to
Your
invoke guidelines issued by the ICMR.
Your lordship, the writ jurisdiction has been invoked because, firstly, fundamental rights have been violated, and secondly, even the principles of natural justice have been violated, your lordship. Nemo juris
Principles
non.
of
No, madam,
natural
madam,
justice.
you are relying on the 2017 ICMR guidelines, correct? So,
Indeed,
same way, are you relying on the ART guidelines of 2005 by the ICMR? No, you're relying on the ART Act of 2021.
indeed.
Because you're before the High Court by writ jurisdiction. That is what my learned brother asked you. Now, in another context, you're relying only on guidelines 2017, which does not have any statutory force. How can that work?
Your lordships, this artificial womb technology would be considered a device under the Drugs and Cosmetics Act, your lordship. Hence, considering this is a device, this would also fall under the pretenses of the ICMR guidelines, where one can ask for permission if human trials can be conducted on this. That is why the contention has been made, your lordship, that we depend and rely on the ICMR guidelines. If your lordships are satisfied, can I proceed with my next argument? Much obliged. Your lordships,
A new drug or a new device under which act? 2019 rules or 1940 rules? Which one? 1945 rules? Which one?
19 rules, your lordship. 19. 2019.
2019. Okay.
Indeed, your lordship. Your lordships, the next submission that I would like to make as to how it has actually caused a grave mental injury is lack of informed consent has violated her bodily autonomy. I think the council needn't say any further because your lordships are already analyzed this angle there, because informed consent has taken away her right to make a choice, which is why I contend this. The third submission would be the violation of bodily autonomy amounting to mental distress. Now, why the council says so is because even in the case of Suchita Srivastava, it has
What
been
is the threshold of medical injury or medical whatever it is that you're relying upon? What is the threshold?
Your lordship, the council has completely relied upon precedents to evaluate a threshold, because otherwise, grave mental injury hasn't been a definition in our legislation so far, your lordship. Much obliged.
What are the precedents? No, what does the precedent say? What is the threshold?
Yes, indeed, your lordship. In this precedent, they have set a precedent saying if a woman does not want to continue with the pregnancy, then forcing her to do so represents a violation of her autonomy and aggravates her mental trauma, which would be deleterious to her mental health. Your lordships, it has
Which
also been,
judgment is this?
your lordship,
Which judgment are you relying upon?
Suchita Srivastava. Your lordships, if you would
What are
permit,
the facts of that case? What was the mental injury that she was facing at that particular case?
indeed, Your Lordship. Your Lordship, I would like to ask my researcher to screen share the compendium while I explain to you the facts of the case. Researcher, please do. Your Lordship, the facts of the case are that Suchita Srivastava is an individual who is admitted in a welfare institution. She has been claimed to be a little mentally retarded, and she is also pregnant because of sexual assault that has happened to her in the welfare
You cannot
institution itself.
exactly. So you cannot take a line from the judgment and then read it out of context. Can you equate the fetus being saved without the mother's consent to a person who's subjected to sexual assault? You
Your
cannot,
Lordship, Your
and
Lordship,
you
to
should
answer
not.
Your Lordship, to answer that, then I would like to rely upon the case of X versus NCT of Delhi, where this case is pretty much mutatis mutandi to us. Why we say so is because here, even this petitioner was promised for marriage, but she wasn't married to, so there was a change in her marital status. In addition to that, she was also an unmarried woman. So, Your Lordships, she also fought
Again,
her case.
another different spectrum. You're talking about an unmarried person. The issues that an unmarried person would face, all those things are different. Here, you have a fight with your husband. There is a possibility of you getting divorced. The divorce is not even the petition was not even filed. So all those are again your apprehensions. Everything happens subsequently.
To answer this question, Your Lordship, I'm not apprehending it. The petition for divorce has already been filed by the husband. That is actually my next
Subsequently.
submission. Yes, Your Lordship. And relying upon the case, why I said she's unmarried is because she is also actually she fights her entire case on the sole basis that she's having mental distress.
Are
Great.
you pregnant? Are you pregnant? No.
Now,
Or have you delivered the baby?
Your Lordship, we would like to believe that we haven't delivered the baby. We are still
So
pregnant in
you're
the
still pregnant. Why? Why? If you're still pregnant, no doubt, MTP would apply. The grave injury to physical or mental health, that is a possibility. How do you prove that you're pregnant?
Your
Do you
Lordship.
have a life growing inside your womb?
Indeed, Your Lordship. To answer this question, I would like to state that as per our current legislations, pregnancy hasn't been defined explicitly anywhere, Your Lordship.
It has been defined. That is the reason why I gave you explanation 3 to section 100. The moment part of the fetus comes out of the mother's womb, right? Which has happened in this case, we are talking about culpable homicide. That is a possible explanation to the definition of pregnancy. If the part of the baby comes out, you're no more pregnant.
Indeed, Your Lordship. To answer this, I would like to politely disagree, Your Lordship. That is because we are still arguing on the basis and ambit of the MTP Act alone, Your Lordship. And in the MTP Act, termination of pregnancy indeed has been defined, but pregnancy itself hasn't. Termination
Define it
of
for us then.
pregnancy, Your Lordship.
Define it for us.
Pregnancy, what sort of legislation would you want, Your Lordship? Would a dictionary definition be appropriate?
Okay, I'll give you two options. Select from this.
Indeed.
From the first week up till 9 months, is that what you call as pregnancy? Or the moment the baby comes out of the mother's womb, once the delivery has happened, you no more call the lady pregnant. Two options. Pick from these two.
Your Lordship, I believe it would be the first option. That is, the gestation period would count as pregnancy, Your Lordship. Post delivery, the women would no longer be pregnant.
Which means you're no more talking about ART Act, right? You're talking about MTP Act.
Indeed, Your Lordship, I would stick to the pretenses of MTP Act only.
All right.
Indeed. Thank you, Your Lordship. Proceeding further, Your Lordship, I would like to proceed to the next argument. That is change of marital status that I've already said. It is in procedure, so I will not argue on that anymore. Your Lordship, the last argument I would like to make is how do we define grave mental injury? It is not explicitly mentioned anywhere, so I would put forward a subjective and an objective point of view. Your Lordship, the subjective analysis would be the individual's perspective. In again stating the case of Sujita Srivastava, it has been evident that the best interest test requires the court to ascertain the course of action which would serve the best interest of the person in question, Your Lordship. Hence, I would like to draw parallel by saying that the best interest of the mother should be kept in mind because she seeks to terminate her pregnancy. Your Lordship, there is a chronology of events that have occurred to this. I would just like to quickly sum up with the chronology. The first event that has taken place is that the paternity of the child has been questioned by the husband. The second incident, Your Lordship, is how the mother, Miss Y, blatantly falls down and injures herself. And she's obviously concerned about the child at this stage as well, Your Lordship. Once rushed into the hospital, the third chronological event is she is robbed of her informed consent right, and her fetus is put into a procedure that is not tried and tested previously, Your Lordships. The fourth submission that, or the fourth contention the council would like to make is how this news was not kept within the four walls of the hospital. It was disseminated with a public news media, which became a public news. Because of the same, the fifth contention that the council would like to make is the husband, simultaneously aggravated by the paternity as well as this information, has decided to file for has decided to file for a divorce. Your Lordships, when considering all of this on the whole, I would like to close with a case that is Page versus Smith. Why I say this is because they use this articulate rule called the eggshell skull rule. In this rule, they say that this establishes that the defendant must take the claimant as they find them, including any sort of pre-existing vulnerabilities that they have. And in this case, we cannot bifurcate the incidents before and after. We might have to take all of it in consonance to declare that Miss Y is actually going through a grave mental injury right now, which is why she wouldn't be in the right mental health to keep this pregnancy. That is humbly contended. Thank you.
That was a very far-fetched argument. That is not what the actual rule is, though. Now, the last question with regard to the argument that you just said about pregnancy part, you are actually arguing for the fetus to be aborted, correct?
Indeed.
Which actually requires the opinion of two registered medical practitioners.
Indeed, Your Lordship.
In India, you follow a system of, if you're following not necessarily Bolito but Bolam, you obviously have a system where the court would actually ask the brothers, or rather, the court would actually ask another team of medical doctors, right? In
Indeed.
this case, you require the permission of two registered medical practitioners. Do you actually think any doctors in Samrat would agree for this particular abortion to actually occur? Do we actually, is there a possibility to get two medical practitioners saying yes to the concept of abortion, and we're actually killing a human life which is not even inside the mother's womb? Because that is the only procedure that courts can do. I hope what I'm saying is right, Adityan sir. Yes.
Yes, yes.
So you require two registered medical practitioners' opinion because you are under MTP. We are not under MTP.
Indeed.
We tried giving that particular point from the very beginning. You're not agreeing to us. Right now, you are under MTP. The girl is pregnant. The lady is pregnant. You're pregnant. Now we require the opinion of two registered medical practitioners. Doctors are trying to save the fetus. If the doctors say yes to this, they are outside the ambit of MTP. They are causing miscarriage or they are causing culpable homicide for sure. Right? Any difference of opinion there with regard to registered medical practitioners?
Indeed, Your Lordship, I'd like to again put forward my point of view. Your Lordship, if these doctors were to consult medical practitioners outside of their ambit of the team of doctors they worked with, I believe the first question that would arise would be that why has the fetus been put into a procedure that hasn't been tried and tested initially, Your Lordship? Indeed, the practitioners would resist
The
themselves.
medical practitioners will have to look at two things. One is the status of the fetus, whether the fetus is suffering from any abnormalities.
Indeed.
Second is the health, both physical as well as the mental health of the mother. So
Indeed.
unless and until there is something inherently wrong with the mother, either both physically or mentally, or with the fetus, the medical practitioner cannot recommend a termination.
Your Lordship,
You
to
might
answer
be depressed, you might be mentally in a bad state, but that cannot be equated to your mental health dropping to a point where the child will have to be aborted. The fetus will have to be aborted.
Your Lordship, to answer to this question of yours, all my submissions have constantly reiterated as to how these precedents do agree with the fact that whatever our client, Miss Y, has gone through actually falls under the ambit of grave mental injury, Your Lordship. Now, coming to the fact that there is
What if you attempt an abortion and the child comes out alive with deformities? What is the procedure that the Bombay High Court has suggested? The mother doesn't want the child.
Your Lordship,
The
which
baby is still alive with
referring,
deformities.
Your Lordship, which case is the Lordship referring to?
There's only one particular decision regarding this thing, Bombay High Court decision. And do you actually believe that anybody in the whole world will be able to cite the proper cause title? It is XXX versus State of Bombay.
Indeed, Your Lordship. Your Lordship,
Huh.
can I ask the question once again?
It's parents patria doctrine. It is the state's responsibility to
take
take care of the child and not to kill the child.
Indeed.
Maybe you can argue that is still persuasive, but then best interest of the fetus, best interest of the child.
Your Lordship, to answer
Caution, I don't think it is possible this way. The way you're arguing, we can't direct. We once belonged to the era where 2013 Gautam Kundu's case, we did not even favor paternity test. Because if at all the paternity test becomes negative, we are bastardizing the child, is what we said. The Supreme Court said. Now you're asking us to kill the child, which is perfectly healthy. It's a difficult thing to do. But then we'll see.
See, now-
We'll see.
Now, if you're talking about medical termination, the child is prematurely taken out from the womb.
Indeed.
So let's assume you're taking the child out from the womb. There is no guarantee that the child will not survive. So you're essentially denying the child of its, fighting chance to survive in the world by taking out all even the artificial womb.
Your Lordship, I would like to rely upon viability here, Your Lordship. A fetus becomes viable. Viability is practically the ability of the fetus to survive outside the mother's womb. Now, Your Lordship, the fetus right now is just 18 weeks old, Your Lordship. The
Hopefully it is
viability of
18 weeks.
surviving, yes, Your Lordship. Suggesting that it is 18 weeks, the viability is close to 3%, Your Lordship. So, taking a preterm delivery wouldn't be the absolute choice, Your Lordship. Hence, Your Lordship, answering the questions that were posed to me earlier, I believe if the medical practitioners do not take an action on this, or if the court does decide to leave this issue as it is, this would become a dangerous precedent as to where every other future mother who decides to use AWT technology will have an understanding of the concept that she is detached of her reproductive autonomy and does not have any rights directly to her fetus and cannot terminate her pregnancy. So, this will set a precedent as such, Your Lordship. That is what is humbly submitted. Hence, please kindly rule in favor of my client. That's what is humbly submitted. If your lordships are satisfied, my co-counsel will proceed with the rest of the issues. Much obliged, your lordships.
The Lordships are satisfied with the contentions made by my co-speaker. I'll move on with the issues. Much obliged, Your Lordship. Your Lordship, the issue I'll be dealing with now is issue 3, which is whether there is a violation of privacy and confidentiality of the patient and other stakeholders. Your Lordship, it is humbly submitted before the Honorable Court that there is violation of privacy and confidentiality of the patient and other stakeholders. My further submissions will discuss the reasons. The first sub-issue is violation of privacy under the Medical Council Act 1956. Lordship, as per 7.17 of the Code of Medical Conduct, under the Medical Council Act, a registered medical practitioner is prohibited from publishing of photographs or medical.
Is there a code of medical conduct?
Yes, Your Lordship. Under the Medical Council Act, there is something called as the Code of Medical Conduct.
You sure that's a nomenclature?
Yeah, yes, Your Lordship. I'm damn sure about it.
All right. Which is the regulation? Number?
7.17, Your Lordship.
Proceed.
Moving on with the contentions, the registered medical practitioner is prohibited from publishing photographs or case reports of a patient without consent of their identities disclosed. In this case, the hospital has failed to do so, where they didn't uphold the ethical obligation to protect the medical.
It's not Code of Medical Ethics Regulations 2002, right? It is Code of Medical Conduct, correct?
Yes, Your Lordship, Code of Medical Conduct.
Okay, by NMC or by the earlier erstwhile MCA.
Yes, Your Lordship.
Again, you're sure, right? It is not Code of
Yes,
Medical
I'm
Ethics.
sure about it, Lordship.
All right, proceed.
Yes, Your Lordship.
Can you show us that? Is that forming part of the compendium?
Yes, Your Lordship. Just give me.
No, we'll search. Code of
Yes, Your
Medical
Lordship.
Conduct. Okay.
I'll move on with the argument, Your Lordship. Much obliged. Your Lordship, in a government hospital, the medical records of the patients are closely protected by the RTI Act and also the Medical Council Act, Your Lordship. So it is nearly impossible for the news channel to access the information of the Subhatra hospitals without their knowledge. So in this case, the hospital has voluntarily given away the personal records to the news channel, which has resulted in serious mental injury of Miss Y, Your Lordship. So
is the MCA Act still valid?
Your Lordship?
Is the MCA Act still valid?
It's still valid, Your Lordship.
Okay, now I got the answer to the first thing as well. The MCA Act is no more. It is NMC.
Your Lordship, under the Medical Council Act...
That's gone. That's gone. They were all arrested under bribery. That's gone. And now it's NMC, National Medical Commission Act, where the earlier regulations by the MCA is still valid. But again, that is not Code of Medical Conduct or whatever you have said. It is Code of Medical Ethics Regulations. Please proceed. Now it is NMC. Instead of MCA, please use NMC.
Yes, Your Lordship. I'm sorry for the mistake. I'll proceed with the arguments. So, Your Lordship, the release of information cannot be substantiated under the 8 clause 1 clause G of the RTI Act. Your Lordship, the sub-issues can be put forward in twofold classification. Firstly, the provisions clearly discuss about when can a private information of the person outweigh the public interest. Your Lordship, an entity is allowed to disseminate an information only when there is an imminent threat to the public or there is a larger public interest. So in this case, the procedure is in success, is still pending ICMR Ethics Committee approval for conducting human trial, Your Lordship. So it will be an absolutely...
Counsel, what essentially is the relief that you're seeking for through this issue?
I'm sorry, Lordship.
What is the relief that you're seeking for? Are you just seeking for a declaration that what the hospital has done is wrong? Or are you seeking something else?
Your Lordship, I'm seeking that the privacy of Ms. Y has been violated in this case.
You only want a declaration. Is that all?
Your Lordship, sorry?
You just want a declaration on paper that the hospital has violated your privacy. That is all.
Yes.
You're not seeking for any ancillary reliefs.
Your Lordship, my further issues will be discussing about the further contentions. According to this relief, yes, Your Lordship, I would like to say that Article 21 has been violated in this case where the patient has suffered grievous privacy invasions.
Are you seeking compensation or anything else?
Your Lordship, the compensation has been sought in a private forum. Like the petitioner has file another petition in a private entity of the Consumer Dispute Forum for seeking relief as an disparity in the public in the
So
service.
once you have approached that court, why do you approach the High Court also?
Your Lordship, the High Court has been approached only because the privacy of the individual has been violated, Your Lordship.
So, but then any observations that we make here would also impact the case that is ongoing at your instance.
Your Lordship, in this case, the High Court has stayed the petition which is being filed in the public forum, which is the Consumer Dispute Forum. So
Right.
they took up the
We'll
case.
remit it back. We'll remit it back. Let the Consumer Forum decide it.
Your
See,
Lordship,
because essentially, does the statement of facts reveal who disclosed all these aspects to the media?
Your Lordship,
Does the statement of facts reveal who is the person who blew the whistle, who
Your
disclosed
Lordship,
all these facts to the media portal?
Your Lordship, in this case, the public media and also the mass media and PNB news channels have clearly, openly have discussed about the case in a public forum. They can't access the information of the Sumatra hospitals without their knowledge, Your
It
Lordship.
could be
So
through
they
your family members.
Your Lordship,
Your family members could have revealed it.
your the family members would have not revealed it because since
Essentially, so what I'm saying
there
is
a
essentially
close
that's a
tie.
question of fact.
Yes, Your Lordship.
Who has revealed it, who has disclosed it, all those can be appreciated only through evidence. Now that you approach the consumer forum, you go before the consumer forum, let in your evidence, and then prove regarding who has violated or who has disclosed all these
Your
confidential
Lordship,
information.
in para 7 of the fact sheet states that the news channels, both the mass media and PNB News, have closely and
Para
the
number
hospital.
7.
Para number 7, Your Lordship, yes. Oh,
Can
sorry,
you read the
Lordship,
relevant portion?
it's the wrong one. Second.
Counsel, did you go through the clarifications given by the university?
Yes, Your Lordship, I went to the clarifications.
You'd gone
The
to the
Sumatra
clarifications?
hospitals were one of the entity who has disclosed the public information of the private records of the patients, Your Lordship, in this case. Without the Sumatra hospital's intervention, there is no possibility of the PNB news channel or the mass media to significantly leak the private matters of the case as well. As mentioned in the case sheet, Your Lordship, going to the
I think it's para 9.
no, Lord. Your Lordship, para 10 of the fact sheet states that the publication of the family's private matters and extensive media coverage. So here the private matters and the media has also leaked the extensive media coverage of the procedure.
The question is who leaked it?
Your Lordship,
Who
the
is the
Sumatra
person
hospital were one of
responsible?
the entity, Your Lordship, who has leaked the information indirectly.
Again, why do you say that? Is it there in the clarification?
Your Lordship, it is not under the clarification, but we can interpret from the case sheet as we can say that without the knowledge of the Sumatra hospital, there is it's really impossible to access the medical records of the patients, the private records of the patients.
The patient will have the records.
The patients will
Two
not
persons will have the
disclose.
records. The doctor as well as the patient will have the record.
Your Lordship, the patient will not disclose their private matters to the public forum, right, Lordship? So, in this case, the PNB News have immensely dependent on the private matters of the case, which has affected an previous mental injury of Ms. Y, Your Lordship.
So on the basis of your arguments, we are supposed to rule that the respondent has violated your privacy. Without any shred of evidence, we'll have to conclude that this is the reason why the news portals have reported the incident.
Yes, Your
Is
Lordship.
that possible?
Your Lordship, my further contention will say about when can an entity or the public forum, I mean the PNB News can disclose the information of the private information only when there is an substantial threat to the society. So in this case, there is no threat to the society, and if at all they want to publish the private records of the person, they need to get approval from the CIPO, Your Lordship, which is the Central Information Public Officer, and State Information Public Officer under Section 11 of the RTA Act. Your Lordship, the entities have clearly violated these rules by disseminating the information publicly, which has resulted in a grave mental injury. Your Lordship. So, Your Lordship, moving on to my submissions. Secondly, when interpreting the provisions under the 8 clause 1 clause J of the RTI, the normal rule should be of non-disclosure of any information concerning one's private life. And disclosure should be ordered only when there is an overriding public interest, which I said in the previous argument, Your Lordship. This case has been, in the case of the G.R. Raval was Director General of Income Tax, they have stated that when an entity is going to disseminate the private information of the person, they need to comply with the procedures which has been established under the Section 11 of the RTA Act. So they have clearly disseminated this knowledge. So, Lordship, moving on with the further issues, there is a
Counsel,
failure.
I think you need to talk to your client, because your client had all these issues starting from the point where in paragraph 8 that has been specifically mentioned that your client had been concerned about the impact of technology on the parental rights.
Yes,
Correct?
your
That's the basic problem, right? Yes or no?
Yes, your Lordship.
Right. Now, if you please take section 31 of the ART Act,
Your
the
Lordship,
Assisted Reproductive Technology Act of 2000. Sorry, did you say something?
I'll just go through it, Your Lordship. Just a
Yeah,
minute.
yeah. Section 31. Section 31 clarifies the whole problem. Talk to your client and ask your client to talk to her husband as well. Matter solved.
Your Lordship, in this
Child
case,
born through an ART. AWT is a form of ART, is what your co-counsel was trying to tell us. Or that's been specifically mentioned in the facts as well. So what is there in section 31? A
Your
child
Lordship,
born through ART shall be deemed to be a biological child.
sorry, Your Lordship.
Problem. A child born through ART or AWT or whatever you call it. AWT is a form of ART, right?
Yes,
Hospital
sir.
authorities have claimed it. Fact sheet says that. Your co-counsel admitted to that.
Indeed, Your Lordship.
So a child born through an ART procedure, in this case, an AWT procedure, right? That is what? That is a biological child. That's been the problem. If you refer to paragraph 9 of the Moot problem, you'll understand. Paragraph 8, last sentence, you'll understand that concerns were about the impact of technology on her parental rights. There is no huge adverse impact.
Your Lordship,
Now, are you claiming violation of privacy?
Your Lordship,
Confidentiality?
as you stated with the clarifications of the university, Your Lordship, coming to the question number 7, they have said that the hospital has leaked the news itself, Your Lordship.
Understood. I am not on that point right now. That is something that I gave you a hint for answering my 11 brothers question. This is another question right now, and I hope it was a very simple question which you understood. What's
Yes,
ART?
Your
What
Lordship.
does this particular provision of ART says?
Your
They are
Lordship,
considered to be the biological parents. The child is considered to be the biological child.
Your Lordship, the Lordship permits my speaker one will be answering for this question since she was
After your
dealing with
round,
the
if we have time, she's already exceeded the time limit.
Your Lordship, since I was
You may continue. You may skip this particular question. You may finish your further
I may
question.
continue with the arguments, Your Lordship. Much obliged. Your Lordship, moving on with the arguments, there's a failure in adherence to the ICMR guidelines. Your Lordship, as per guideline 2.3 of ICMR, it states that confidentiality is a fundamental obligation. The hospital and stakeholders violated this by granting unauthorized access to medical records, leading to the public telecast without the patient's consent. The breach of trust and ethics demands strict accountability in this case, Your Lordship. So moving on with the case, that's this case, Puttuswamy case. A commission was formed under the B.N. Krishna Committee, where they submitted a report along with a draft bill on personal data protection, Your Lordship. So they classified the data into 3 types, Your Lordship, which is personal data, sensitive personal data, and critical personal data, Your Lordship. So in this case, the sensitive data, personal data of the private matters of the Miss Y has been leaked in the public forum, which amounts to a grave mental injury to the Miss Y. When they leak the sensitive, when they disseminate the information of the sensitive data, they need to get permission under the section 11 of the RTA Act, which they clearly failed to do so. Your Lordship, this is my contentions regarding the issue 3. If the Lordship
What's
has
the public
satisfied,
interest involved in here,
Your
as
Lordship,
opposed to the private interest? What's the public interest? Because that was your opening statement.
yes, Your Lordship,
If the public interest do not outweigh the private interest, that is definitely a violation of right to privacy.
yes,
So what could be the public interest involved in here?
Lordship, am I audible?
You are.
Yes, Your Lordship. There is when can when can an private information of the person be disseminated in the public forum is when and there's a larger imminent threat
Public
to the
interest involved. So what I'm asking is, what is the larger public interest involved? Don't you think there is a public interest involved? What is it?
Your Lordship, there is, if the procedure was a success and it was also, if the procedure got an ICMR ethics
Different
committee,
members of the public could be benefited from the same. Correct.
yes, Your Lordship,
Yes,
indeed,
the
but in
procedure
this,
was a success, counsel.
Indeed, Your Lordship, but in this case, they have failed to get the ICMR human trial
Unless that
approval.
is a different issue. That is a different issue. We are on PNB and liabilities of hospitals. You
Yes, Your
just
Lordship.
confessed. You just confessed to the point
Your
that
Lordship, yeah,
if
yes, Your
the
Lordship.
if the procedure is a success, that is something that the public needs to know. The public need to know. Correct. The
Correct, Your
procedure
Lordship.
was a success. They were able to save the babies. What the fact she said. So the
Your,
public interest definitely outweighs the private interest, counsel. You have admitted to that just now.
Your Lordship, may I answer to this question, Your Lordship? Much obliged. Your Lordship, in this case, as you said, there is an larger public interest. But in this case, when an procedure has been leaked or disseminated in the outside world, they should have also informed about the unethical approval of the ICMR guidelines. But they haven't disclosed about the issue. Your Lordship, if the public comes to know about the ICMR, which they
Okay,
failed
then
to
tell us
get,
understand. Tell us the procedure, please. Tell us the procedure. Now that assuming for the time being that
yes,
both of us are agreeing to this being a biomedical research, we haven't agreed. Assume what exactly is the procedure before taking up this particular procedure? Which all approvals is required? Which all ethics committee approvals are
your,
required?
your Lordship, Your Lordship, sorry for the disturbance. Your Lordship, the
I
person
think that's
should
your co-counsel messaging you.
no, no, Your Lordship.
Yeah.
It's not.
Okay.
Your Lordship, they have to first of all get an ICMR ethics committee approval. That's the first thing, first and foremost thing
ICMR
before
ethics committee. So I thought it was an institutional ethics committee that has to be constituted first because it was a
institutional. Your Lordship, institutional ethics committee also need to be given, but ICMR, since it governs the whole India, it needs to get the ICMR committee approval as well. So, like they have clearly
fact. You
failed to do
talked
so in
about a
this case.
scientific committee or something of that sort. What is that then?
So, Your Lordship, they have gotten the scientific approval committee in the hospital, which is in the hospital, Your Lordship.
So is that the same as the institutionalized ethics committee?
No, Your Lordship, both are different entities because
So where is this mentioned? Scientific committee. I did not come across any sort of
Your Lordship,
regulations or law.
they have failed to get an basic approval, which is conducting a human trial approval from the ICMR committee itself. So this clearly says so,
Why
Your
don't you
Lordship.
read the relevant provision so that you can convince my brother judge regarding that point?
Your Lordship, I would just take a minute in this case.
Ah.
Please oblige, Your Lordship. Lordship, like I would like to come back to this question later. I'll move on with the issues further, Your Lordship. Much obliged. Your Lordship, coming back to issue 4, it states that whether the petitioner can invoke a private law remedy simultaneously with the public law remedy. Your Lordship, it is humbly submitted before the Honorable Court that the petitioners have the right to invoke a private law remedy simultaneously with the public law remedy. An aggrieved consumer has recognized in various precedents has the right to pursue simultaneous remedies under the public and private law for holistic adjudication of grievances. In this, Your Lordship, Ms. Y has filed an writ petition in a public forum to challenge the right to privacy, Your Lordship, and she filed a private remedy in the Consumer Dispute Forum for seeking an compensation of rupees 5 crore for deficiency of services, which has been in the Sumatra hospitals. So, Your Lordship, both are two distinct scenarios. Furthermore, the court emphasized that the consumer proceeding should proceed expeditiously, even if parallel criminal cases. I mean, in this case, Your Lordship, which is the Ratna Ghosh, and another was Dr. P.K. Agarwal, highlights that a complainant can initiate proceedings across civil and criminal courts, consumer forum, and professional regulatory bodies to seek comprehensive justice. In this case, Ms. Y has seek for
You're talking
comprehensive.
about civil and criminal remedies, not two civil remedies at once.
Your Lordship, in this case, criminal, which comes into the public body. Here, in this case, we are challenging the constitutional remedy, which comes into the public body as well.
Both of them are essentially civil in nature.
Yes,
you're essentially seeking compensation through both these cases.
Your Lordship, in this case, both are distinct thing, Your Lordship, because we are seeking
the cause of action is distinct, or are you
the
saying
cause
that
of action
the
in this
remedy
fact
chosen
sheet factual matrix states that we are seeking a private law remedy just because that's a deficiency of service which is being done by Sumatra hospitals. For public law, we are saying that there is an
violation of your
violation of Article 21 privacy violation. Yes, Your Lordship. So moving on with the case, Your Lordship. My Lordship, I would like to state a case here, which is KK Saxena was International Commission on Irrigation and Drainage. They have said that The Honorable Supreme Court clarified that private law remedies cannot be enforced through writ jurisdiction under Article 226. So the court distinguished between public and private law, emphasizing that private law governs individual relationships such as contracts and torts, which must be adjudicated through ordinary civil proceedings. Even if a writ petition is maintainable against an authority, the court must first ensure that the issue falls within the domain of public law before granting relief. So contracts and commercial
Where
disputes
could you
should be resolved.
understood the point, understood the Saxena's
Yes, yes.
case? Where could you parallelly possibly place the High Court's jurisdiction when you talk about the consumer forums?
Your Lordship, I can say that Article 226 has a broader perspective.
I'm sorry, I'll rephrase the question. You have a district forum, a state forum, and a national forum.
Yes, Your Lordship.
If you parallelly place the High Court's jurisdiction, where would that be? Is the High Court's jurisdiction same as that of the district forum, state forum, or the NCDRC?
It will be
Because
in the
the
national.
appeal from NCDRC goes to the Supreme Court, if I'm right.
Your Lordship, this I would say that it is like impossible to compare both the petitions, Your Lordship, because
Really, if it is
That is not
impossible,
the question.
in the statement of jurisdiction, it could have been 227 as well, not just 226.
Your Lordship, since 226 gives a wide bracket of definitions, since
True,
like
true. For all the other purposes, that would sustain, but not for this. Any disputes with regard to consumer forums has gone to the High Courts under 227 jurisdiction.
Your Lordship, 227 talks about the supervisory power of the High Courts, Your Lordship, but in this case,
All the other tribunals, and you
Yes,
classify this as a tribunal, this might work. You have got case laws, you have got precedents on this, but you have not done that in your memorial. I don't see that. We did not see that.
Your Lordship, as I said before, since 227 talk about supervisory power of the High
Now, what's the
Courts.
pecuniary jurisdiction of the forums?
Your Lordship, can you come again with the question?
What's the pecuniary? What's the jurisdictions? What's the jurisdiction of district, state, and national forums?
Your
Under the
Lordship,
Consumer Protection Act.
Your Lordship, that since that's a separate petition which is being filed by Ms. Y, it doesn't support this
Question.
What are the jurisdictions?
jurisdictions which has been challenged here is Article 226, Your Lordship. I mean Article 21 of the Privacy, Your Lordship. Under 226, we are not bringing for the 227.
You have filed for getting 5 crore compensation before the state consumer forum, correct?
Yes, Your Lordship.
Not exactly sure, but then this would have been correct if it was before 2021. Post 2019, correct. The act changed everything. Massive powers, massive increase in the pecuniary jurisdiction was given. But post 2021, I'm afraid that was taken back a bit because all the petitions started to be, reaching the district as well as the state forums. So what they did was they reduced the pecuniary jurisdiction. So I'm not really sure on this particular point, subject to correction. I don't think you can approach the state forum with a 5 crore compensation claim now. So from that point onwards, if what I'm saying is correct, from that point onwards, there's been a problem. Please cross-check. Maybe you may rebut this thing during your rebuttal time or whenever.
I'll be rebutting this during the rebuttal time.
2021, I think there's been a reduction. 2021.
Yes, Your Lordship. I'll be coming back with this. I'll be moving on with the issues. Later, I'll discuss this.
Too much time?
Too much time, I guess, Your Lordship. I'll move on with the fifth issue, the last issue. I'll wrap it up soon.
How much time, sir? How much time more to be given? I think they've exceeded the time limit.
They've exceeded the time.
Number.
So, Your Lordship, I will move on to the prayers then.
No, finish the contention.
Yes, Your Lordship. Moving on to the issue 5, Your Lordship, whether the transfer of fetus to the artificial womb without conducting proper clinical trial is violative of the drugs and cosmetics rules or other laws. Your Lordship, it is submitted before the hospital, before the court that the hospital has not acquired the approval of the ICMR Institutional Ethics Committee before conducting the experimental procedure. As per 3 clause B clause 4 of the Drugs and Cosmetics Act, drugs includes devices intended for internal or external use of diagnosis, treatment, mitigation or prevention of disease or disorder in the human beings, Your Lordship, as notified by the central government. Your Lordship, the AWT procedure falls within the definition.
Just one question. Does the law prohibit a doctor from using an unconventional means, for example, unconventional technology which has not been approved by the ICMR, for the sole purpose of saving a life?
You can't rely on this, Your Lordship, because
It's been prohibited. Which law prohibits it?
Your Lordship, in which law, you were asking which law prohibits like the.
You're saying that it's not possible. So which law interdicts the use of such technologies which is not approved by the ICMR for the purpose of saving a life?
Your Lordship, I would like to move on with the Rule 122 DAC of the Drugs and Cosmetics Act, Your Lordship, which says that mandates the prior ethics committee approval, which compliance with the good clinical practices. So they should get a mandatory ethics committee approval before conducting an trial, which is being yet to get an ICMR guideline ethics, Your Lordship.
You're essentially saying
Even
that this is a trial. My question is not that. My question is, can you use a technique which has not been approved by the ICMR or under the rules for the purpose of saving a person's life?
Your Lordship,
So if it is done, is it made an offense or
Your Lordship,
is it interdicted expressly?
Your Lordship, in this case, the doctors would have used alternative methods
No,
for
forget this
saving
case.
the life.
Forget this case. I am asking a general question.
Yes, Your Lordship.
Does the law in any law prohibit a doctor to use such techniques?
Your Lordship, and medical practitioner can act in good faith and save a life. It is an moral obligation of the moral ethical obligation of the doctors, Your Lordship.
Okay. Okay.
But I'm not sure whether the medical practitioner can act upon it when there is when they haven't got any approval of the clinical trial approval or something, Your Lordship. I think it will be morally and ethically wrong in this case, in this scenario, Your
To
Lordship.
save the life through a technique which is not
To
approved
save a
is
life.
morally wrong.
If at all they need to save it, that should be an informed consent which is being given by the patient or the family members in this case. But in this case, they haven't gotten any approval from the patient or the family members in this case. So the facts are silent in this case, Your Lordship. Much obliged, Your Lordship. So with this, I will conclude with my arguments and I'll move on to the prayer, Your Lordship.
One more. Any difference between a drug and a new drug?
Your Lordship, yes, Your Lordship, there is a distinction between this. I mean, what I'm trying to say is both should be ethically and morally approved by the ICMR guidelines.
No. A drug as defined under the Drugs and Cosmetics Act, prove your point, because that might also include a medical device, a medical support.
Yes, Your Lordship.
But we are talking about a new drug, which requires approval. Correct?
Yes, Your Lordship.
For which the definition is there in the 2019 rules. And I don't see a medical device being a new drug. That is why I'm asking.
Your Lordship, the council has not researched with a new drug in this case, but the council has moved on with the drugs, which is mentioned in the 1940 Drugs and Cosmetics Act. So in this case, they have used like they can move on with the treatment when there is an like as I said before, the treatment can be done, which is a medical use of the technology, Your Lordship. So I would like to
again one last question. What is the consequence if we hold that the transfer of the fetus to the artificial womb is in violation of the Drugs and Cosmetics Act? How will you benefit out of this?
Your Lordship,
I'm talking about the practical aspect of it. Because
yes,
for a legal discussion, okay, this is fine. But what does your client gain from this practically?
So, Your Lordship, in this case, I would say that the transfer of fetus to an artificial womb questioned her parental rights.
Already been done. This has already been done. You've also sought for termination of that pregnancy. My question is, how does the fifth relief help you in any manner?
Your Lordship, this seeks an prayer that the fetus being transferred from the mother to the artificial womb question the parental rights. So this can substantiate that the parental rights.
What is the consequence if a person contravenes the Drugs and Cosmetics rules? What will happen?
Your Lordship,
what is the consequence if a person violates the Drugs and Cosmetics rules? Is it a punishable offense?
Your Lordship, it is an punishable offense. The doctors can be held liable for the actions which is being done by this, and also the hospitals can be shut down. And also, if there is an procedure being conducted without the consent of the patient.
Which provision?
Your Lordship. Your Lordship, if I could come back with
you can come back. Okay, that's it. You can conclude.
Yes, Your Lordship. I will move on with the prayers. Your Lordship, in the lights of the facts stated, arguments that authorities cited, the petitioners shall be duty bound that to declare that Ms. Y is entitled to terminate her pregnancy under Section 3, Clause 2, Clause B of the MTP Act, hold that the transfer of the fetus to an artificial womb without her consent violated her autonomy and mental health under the MTP Act, rules that the hospital's actions breached right to privacy and confidentiality of Article 21 of the Constitution. Also, Ms. Y, to seek both private and public law remedies simultaneously, find the hospital in violation of the drugs and cosmetics rules for conducting unauthorized clinical procedures without proper approval, Your Lordship. So, henceforth, the petitioners may conclude with this. Much obliged, Your Lordship. Your Lordship, the answers will be done in the rebuttals part. Thank you so much, Your Lordship.
With the permission of the judges, I now invite Speaker 1 of the respondent to present their arguments.
Am I both audible and visible to the honourable bench?
Yes.
Much obliged, Your Lordship. Greetings of the day to the honourable bench. The council seeks permission to address the bench collectively as Your Lordship.
Yes.
Much obliged, Your Lordship. I am Sweksha Gupta, and together with my co-counsel Meenal Gupta, we will be representing the respondent in the case of Sumantra Hospital. We will be representing the respondent, Sumantra Hospital, in the case of Miss Y versus Sumantra Hospital and Research Center. Your Lordship, the Honorable High Court has delineated 5 key issues in the present case for the submission, and I will be dealing with first, third, and fourth issues, while my co-counsel would be presenting the arguments for second and fifth issues. Does Your Lordship require the counsel to summarize the facts of the case, or shall I proceed directly with the submission?
You can proceed to the arguments.
Much obliged. Going ahead with my submissions for the first issue on applicability of the MTP Act on the present case, the Council, through a 3-pronged submission, contends that Ms. Y cannot demand the abortion within the purview of the MTP Act because, firstly, the term pregnancy within the Act should be interpreted literally and strictly. Secondly, that if the fetus is permitted to sustain with the aid of artificial womb, it won't affect the bodily autonomy of Y. And third, the state has a compelling interest in protecting the life of the fetus. Beginning with my first submission, that the term pregnancy should be interpreted literally. Your Lordship, the literal rule of interpretation mandates that words of a statute, if not ambiguous, must be first ascribed their ordinary and natural meaning. Now, in the present case, the long title of the Act mentions that it is an act to provide for the termination of pregnancies and matters incidental thereto. Further, Section 3 of the MTP Act enlists all the grounds for terminating pregnancies by registered medical practitioners. Now, if we ascribe a dictionary meaning to the term pregnancy, it necessarily involves a fetus in the body of a female. For instance, Black's Law Dictionary defines pregnancy as the state of a female who has within her ovary a fecundated germ. In other dictionaries as well, like Oxford Dictionary, it is defined as a stage during which a woman carries a developing fetus. It is submitted that if the term pregnancy is ascribed to its dictionary meaning, no ambiguity arises in understanding the meaning of the word. And
Have you
therefore,
logged in through your mobile or laptop?
pardon your lordship,
Are you using Google Meet through your laptop or mobile phone?
I'm using it through my laptop.
Which is an extension of yourself?
Sorry, your lordship.
Which is an extension of yourself? The technology that you're using right now, can you deny the fact that it's not you who's arguing? You obviously want us to believe that you're so and so Gupta, or that was, yeah, right? That is an extension of yourself, correct?
Could you please rephrase the question?
The artificial womb, can't that be considered to be the petitioner's womb in the instant case?
No, your lordship. The artificial womb cannot.
The surrogate mother has right. Who's the biological mother?
As far as the termination of pregnancy is concerned, the mother which is carrying the child, which is the surrogate mother, has the right to determine has the right to determine on the life of the fetus.
Really?
Yes, your lordship.
You might want to read the law again. I don't think the surrogate mother has that particular right. Because at the end of the day, you're talking about who's the biological parent in the case of surrogacy?
Uh,
Law deems the biological mother to be whom? In a case where the oocyte is taken from X, surrogate mother becomes Y. Who is the biological mother?
it is deemed that X, whose
Right,
eggs
right,
are
right.
there.
Now place AWT instead of or in place of surrogate. Who is the biological mother?
In the present case, Miss Y is
Petitioner.
the,
The
yeah.
petition.
Petitioner. So she can claim abortion according to the provisions of MTP. If
It
the
is some.
consent, if the consent has been taken, now in this case the consent is not taken, is what they argued. Correct. If the consent is taken, even the ART Act gives the commissioning couple a right to withdraw the consent. After everything has been done outside the mother's womb, before it has been placed into the mother's womb, the commissioning couple can withdraw the consent. That is section 22. You can withdraw the consent if the consent is taken. Here, consent is also not taken, right? And in fact, the 2002 regulations, Code of, not medical conduct, that is what the petitioners argued, but Code of Medical Ethics Regulation specifically says that if not the wife's consent, if not the mother's consent, the husband's consent, the father's consent should be taken, which was also violated. So, what is the chance that you're giving them?
It is humbly submitted that in the present was given the emergency situation and the paucity of time, the respondent hospital deemed it fit to intervene and transfer the fetus to the artificial womb. However, now since the fetus is stable as per the fact sheet, now the state has an interest to protect the life of the fetus.
See, a person should not be left remediless, right? So here somebody has done something without the consent of the mother. They've shifted her to an artificial womb. Now you're saying that because it's an artificial womb, she will not be considered as a biological mother for the purpose of seeking termination of pregnancy. What can she do then? Which is why I was asking the first question. Let the state take over the child and you look after the child.
And possibly the mother may not want that as well because you are trying to take care of the child under the provisions of Juvenile Justice Act. You talk about children's home and all that. That is the only missionary states have. Obviously, no mother would actually want that as well. She doesn't want the child to be alive. That's her decision. That's the choice that MTB gives.
And it is better that the child is, the fetus is not born in comparison to the facilities that you're going to offer to the child.
Your Lordship, it is humbly submitted that the present case presents a conflict of rights between the right to life of a fetus vis-a-vis the right to reproductive autonomy of Y.
Correct.
And the courts have always given the precedent to the right to life of a fetus in such a
No,
situation.
no, 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 no.
No.
Can't agree to that. Every time. Site authorities. I'm sorry for saying that. Site authorities. Because we do have a collection of authorities where till the birth, it is the right of the mother which has been given precedence. Till the birth. I can even read the particular quote as well. The fetus up to the moment of birth does not have any separate interests capable of being taken into account. Everywhere, it is the mother's interest. It may be because of our ignorance. Please do cite authorities to prove the point.
Your Lordship, to life of the fetus, wherein during the initial period of development, when the fetus is not yet viable, precedence is given further to cite, in the case of X versus Union of India, the court had denied the right to the court had denied the termination of pregnancy rights to the women, considering it was a 27
Just a
weeks.
moment. Researcher, you can stop the screen sharing.
Sorry, Your Lordship, pardon.
I'm asking the researcher to stop the screen sharing. Okay, now you can. Continue.
Proceeding to my second submission, that if the fetus is permitted to sustain with the aid of artificial womb technology, it won't affect the bodily autonomy of Y. It is respectfully submitted that the MTP Act enshrines a woman's right to reproductive autonomy, which protects her freedom to freely decide matters relating to her sexual and reproductive health. The right to bodily autonomy is the cornerstone of the Act, empowering a women to make informed decisions about her own body.
See,
However,
one doubt. So the medical practitioners in this particular case has declined to consider the request of the petitioner, holding that the fetus is not within the woman's body. Does the MTP Act provide the medical practitioner with any kind of adjudicatory power to decide whether the particular set of facts and circumstances would fall within the ambit of the Medical Termination of Pregnancy Act? What is the ambit of their rights or their duties under the Act?
Your Lordship, it is submitted that the registered medical practitioners are themselves empowered by the MTP Act. Given the situation that the MTP Act is not applicable in the present case, they
Can they
denied.
make their adjudication? Does the MTP Act permit the medical practitioner to make an adjudication as to whether MTP can be given or not? Or is the medical practitioner only supposed to form his opinion regarding the points prescribed under 3B2, 1 and 2?
Your Lordship, definitely, a registered medical practitioner does not have a adjudicating function. However, since the pregnancy in the present case was not a traditional pregnancy wherein the fetus is present in the womb, that is why the
Did the
doctors
medical
denied.
practitioner assess the risk of the pregnancy of the fetus or regarding the mental health of the mother?
Your Lordship, in the present case, the fetus was reported to be stable after the procedure.
Where?
It is given in the fact sheet.
Where in the statement of facts?
Page number 3, para 8. It states,
The
however,
fetus was stable after the procedure,
yes, your
but
Lordship.
you're not sure whether there will be future complications or not.
In that respect, I would like to bring the attention of the Honorable Court to para 5, page 2 of the Moot Prof. It states that researchers have suggested, line number 5.
Correct. Okay.
It states that researchers suggested that the benefit of an artificial womb is that it enables a fetus to develop outside the mother's body, eliminating potential risks or complication associated with pregnancy and childbirth. Further, it could also create a more controlled environment free from pollutants that might lead to birth defects or future health issues. Thereby, the potential risk that there might be some fetal
But
abnormality or
shouldn't it have been assessed by the medical practitioner? Shouldn't the medical practitioner assess the child, the fetus, and then decide whether there are any abnormalities or not? Shouldn't the medical practitioner talk to the mother, assess her mental conditions, and then come to a conclusion that there is no grave mental issue with the mother? Rather than doing it, you have gone on to an adjudicatory process, which is not even permitted by the statute.
Your Lordship, the medical practitioners did report that the fetus is stable after the procedure.
No, it's not the medical practitioner who has reported it. It's the hospital. Para number 8 is before the application was made to terminate the pregnancy.
Your Lordship, then it can be presumed that the registered medical practitioner would have themselves conveyed it to the hospital authorities, because it is
Before the
ultimately
application.
Sorry, Your Lordship.
So you're saying that even before the application was made by the petitioner to terminate the pregnancy, the medical practitioner had already assessed the baby. How is that logical?
They had already assessed 3B.
You can continue. You can continue with your argument.
continuing with my submission, that if the fetus is permitted to sustain with the aid of artificial womb, it won't affect the bodily autonomy of Y. It is respectfully submitted that the MTP Act enshrines a woman's right to reproductive autonomy, which protects her freedom to freely decide matters relating to her sexual and reproductive health. The right to bodily autonomy is the cornerstone of the Act, empowering a woman to make informed decisions about her body. However, Your Lordship, the instant case presents a different perspective where the fetus has been transferred to an artificial womb for nourishment and sustenance and is no longer dependent on Y's body for its development. Since the fetus is outside the Y's body, allowing it to continue its sustenance will not violate her bodily autonomy in any manner, and therefore Miss Y should not be allowed to claim termination of pregnancy under the MTP Act. Thirdly, the state has a compelling interest in protecting the life of the fetus. Your Lordship, if we go through the entire scheme of the MTP Act, it places the interest of a mother on a higher pedestal than the interest of a prospective child. However, this is based on the logic that the fetus cannot have an independent extrauterine existence and is completely dependent on the mother. And therefore, the life of the mother on whom the fetus is dependent is entitled to have greater consideration. Your Lordship, it is necessary to note that a fetus in a mother's womb is recognized as a non natural yet a legal juristic person having life. Further, various judgments of the High Courts have recognized that a fully developed fetus has a right to life under Article 21. Moreover, Your Lordship, it is pertinent to note that in Suchitra Srivastava versus Chandigarh administration, the Honorable Supreme Court has held that there is a compelling state interest in protecting the life of the prospective child. The court, time and again, has iterated that it is ethically and legally impermissible to terminate the heartbeat of a viable fetus, which is the case in the which is the situation in the present case where the fetus has become viable. Again, turning to the facts of the case, Your Lordship, this case
Counsel,
presents.
why do you call it a fully developed child? Is there anywhere stated in the facts that the child has been kept out of the AWT? The
Uh,
child is still in the womb. It is just that the child is not in the mother's womb.
Indeed, Your
The child is
Lordship.
in a womb. It is just that it is an artificially created womb.
Indeed, Your
So
Lordship.
the Supreme Court precedents that you cited will not be applicable here. Article 21 reads.
Your Lordship, but in all those cases, the fetus had become viable, and so has the fetus become viable in the present
What do
case.
you mean by
Because,
fetus becoming viable?
Your Lordship, viability is defined as a stage of development after which a fetus can exist independently of its mother in
Correct.
an artificial setup,
Which means independently of the womb.
independently of the
Mother's what?
mother's womb.
Right. And we have, inside the mother's womb, we do have an artificial womb. So can you say that the child is viable?
Your Lordship, the definition of viability means when it's defined as such a state of development wherein the fetus can exist independently of the mother's body. However, depending on the
The
artificial
viability of the fetus, does it mean that the fetus is the medical condition of the fetus would indicate that the fetus would be born healthy?
uh, pardon, Your Lordship.
Does the viability of a fetus mean that the medical condition of the fetus at present is such that there is every possibility that the fetus, if born, would be healthy?
Your Lordship, viability is defined as a stage where it can exist independently on the support of artificial systems.
After
Not turning
after being born.
No, even before being born. For example, premature delivery, or
Even
in few
premature
cases,
delivery requires delivery.
and in the cases where the fetus. So, for instance, in X versus Union of India, the court deemed it ethically and legally impermissible to terminate the heartbeat of a viable fetus, and the 27 weeks old fetus was considered a viable fetus.
Even the Supreme Court has recently terminated a 32 week old pregnancy on the ground that it would affect the mental capacity of the mother. So, where do you draw the line?
Your Lordship, in the present case, Your Lordship, in the present case, the right to life of a fetus is against the right to reproductive autonomy of Y. And as far as the ground of valid ground, and this will be further in detail addressed by my co-counsel, because my issue is particularly limited to the application of the Act in the
Okay.
present case.
You can move on to the next issue.
The council would now like to move forward to the third issue, that is on violation of privacy and confidentiality of the patient and other stakeholders. It is respectfully submitted that the privacy and confidentiality of Y and other stakeholders has not been violated because, firstly, the petitioner has not exercised the alternative legal remedies before approaching the High Court under the writ jurisdiction. In arguendo, secondly, the media has the right to publish, circulate, and broadcast information, and privacy is not one of the reasonable restrictions enlisted under Article 19, Clause 2. And thirdly, the general public has a right to receive information on matters of public importance. And fourthly, Sumatra Hospital cannot be held vicariously liable in the present case. Beginning with my first submission, that the petitioner has not exercised the alternative legal remedies before exercising the writ
Is it
jurisdiction.
commercial speech a part of Article 19(1)(a)?
Sorry, Your Lordship.
You said that privacy is not a reasonable restriction under 19 clause 2. And you
Uh,
related that argument to broadcasting. So is commercial speech a part of Article 19(1)(a)?
The right to free speech and expression of journalists and press has been recognized under Article 19.
Commercial speech. Is that part of 19(1)(a)?
If you could please elaborate, what did you mean by commercial speech?
Right to advertise, for example. Right
Yes,
to advertise, very hypothetically, not even connected to this particular problem. Right to advertise a particular procedure to save a fetus.
right
that
to
part of 19(1)(a)?
advertisement by itself is indeed a part of Article 19, Clause 1A.
Okay. All right.
Your Lordship, it is humbly submitted that the Cable TV Network Amendment Rules 2021 establishes a three-tier complaint redressal structure to address the grievance of a person aggrieved by a telecasted program on a TV channel. And as a part of this complaint redressal structure, any person aggrieved may file a written complaint to the grievance officer of the respective broadcaster. Further, public TV channels such as the Doordarshan are regulated by the Prasar Bharati Act, and Section 5 of this Act also establishes a broadcasting council to address the complaints of an aggrieved. If your Lordship could kindly refer to page 3, para 12 of the Moot prop, it states that Ms. Y has directly approached the High Court and filed a writ petition against the PNB News Agency without approaching either the grievance officer of the broadcasting channel or the.
But when there is an allegation of violation of right to privacy, it's a fundamental right. The High Court or the Supreme Court are the appropriate remedies available.
But your Lordship, the statute itself, through cable TV network rules, provides a remedy to the petitioner, and as per the rule of exhaustion of statutory remedy, she should have exercised those remedies first.
Don't we have precedents that have said otherwise, as that exhaustion of domestic remedies is not a point when it comes to Article 226?
Indeed, your Lordship, but in a recent case, it has been held that an alternate remedy agreed by itself does not divest the High Court of its powers under Article 226 of the Constitution, but a writ petition should not be entertained when an efficacious alternate remedy is provided by the law.
So there is violation of right to privacy. The point is that it is not covered under Article 19 Clause 2 as a reasonable restriction. Plus, they did not go to the appropriate forum. But you admit the fact that there is violation of right to privacy, correct?
Your Lordship, if I can get a minute.
Maybe you may come back to this particular point later.
Yeah, I would like. Thanks so much. With that, the council would now turn to the second prong of the argument, that the media has the freedom of speech, which is only restricted by reasonable
See,
restrictions enumerated.
Council, earlier you cited a lot of decisions regarding medical termination of pregnancy. If you've noticed one thing, all the cause titles says X versus State of Kerala or X versus Union of India, all those things. Why do you think that the name of the petitioner was masked in all those cases?
To maintain the privacy of
Correct. So,
the petitioner.
don't you think that the Supreme Court's decision on the point is relevant? And the Supreme Court, despite knowing it, has masked the name of the petitioner. The name and the details of the petitioner, or even in this case, the lady, was not necessary for you to publicize the matter. But you chose to divulge the details, personal details of the petitioner as well as her family.
Your Lordship, if you may please refer to the Moot prop, para 9 of the Moot prop, page 3. The last second line, it states that mass media reported the story and the state-run media agency, PNB News, extensively reported on the case and detailed information about the situation was being telecasted.
Correct.
However, it doesn't mention that any information which was private in nature as such
First
was
sentence of paragraph 10.
It states that the publication of the family's private matters and the
Which
extensive
may include identity.
Exactly.
it doesn't necessarily mean identity.
Then how did Mr. X find out that it was Mr. Y, Miss Y? If
So
it is someone else, if it is all concealed, how would Mr. X have sent the divorce notice in the first place?
Your
Something
Lordship, the
seems to be
facts
improper on the
are
fact.
silent on the case as to how Mr. X
Let's
got
forget
to know
about the
about that.
name. Let's forget about the name. But you do admit the detailed information about the situation was being published.
Yes, indeed, Your Lordship.
Correct. So is that permissible?
Uh, that would be addressed by my third argument, that the general public has the right to receive information on the matters of public importance.
How is this
Uh,
of public importance? This is a
your
personal matter. This is a personal matter involving the bodily autonomy of a woman. How is this a matter of public importance?
Your Lordship, the information shared by the PNB News pertain to matters of public health and safety and the intersection of technology with reproductive rights. And what is their social and ethical and legal consequences and implications. And further, this detailed information that was telecasted about the situation was in the furtherance of the duty to inform the matters in the public interest. And since this was the very first time when technology of this sort was used to save the fetus, it does become a matter of public importance.
Proceed, proceed.
Indeed, Your Lordship. Continuing with the second prong of the argument, that the media has the freedom of speech, which is only restricted by reasonable restrictions enumerated under Article 19, Clause 2, it is humbly submitted that freedom of the press, guaranteed under Article 19, Clause 1, Subclause A, is regarded as the mother of all liberties in a democratic society. And a free and uncensored media is essential in any society to ensure freedom of opinion to ensure freedom of opinion.
Which
To
one do you think is wider, privacy or morality? Because morality is a ground under 19 clause 2 to restrict freedom of speech and expression.
Your Lordship, we cannot. I'm unable to understand how can we compare morality and privacy as
Cannot
two.
be compared. Cannot be compared. Something is immoral through the exercise of freedom of speech and expression. That is a valid ground for restricting it. Correct. Correct.
Yes, yes, Your
But
Lordship.
if the dissemination of information leads to somebody's divorce, isn't that immoral?
Your Lordship, the reasonable restriction of decency and morality has been interpreted in the sense of with an angle of obscenity in most of the cases by the Supreme Court.
Not with regard to any other sense of immorality. Okay, proceed.
No, no, Your Lordship. And further, even if it goes beyond sexual morality, it has to be of a very serious nature. And this has been held in a case, if I can refer the case after my arguments, please.
Yes.
Yes.
Further, in the landmark judgment of Kishore versus State of UP, the Honorable Supreme Court observed that the restrictions enlisted in Article 19, Clause 2 for restricting the right to free speech are exhaustive in nature, and
Any
any
connection between 19 clause to 2114? Any connection?
Your Lordship, the Council is presently pleading that Article 19 Clause 1, Subclause A empowers the media to report the matters, and these are restricted only by
But is
Article
there any
19 Clause
connection?
2
That is the question. Is there any connection between the three?
between 14, 19, and 21. It is the golden. They are referred as the golden triangle.
And where do you have privacy? Right to privacy we mentioned, if not under 19 clause 2?
Uh, it is mentioned under Article 21.
Not mentioned though, but
Yeah,
implicitly being brought in.
derived. Yeah.
Don't you think that would serve as a very valid restriction?
But Your Lordship, in this landmark judgment of 2017, the Supreme Court has itself said that the restrictions which are mentioned in Article 19, Clause 2 are exhaustive, and any additional restriction which is not found in Clause 2 cannot be imposed under the guise of invoking other
Which
fundamental
judgment?
rights.
Which judgment?
Kaushal Kishore versus State of UP.
2017. What about
Yes.
Puttaswamy, which also came in the same year? There should be a law to restrict right to privacy. There should be a legitimate aim, and that should be the proportional restrictive measure, which will be the least restrictive measure. You haven't followed any of these here. Is there
But
any
Your
law
Lord,
that actually? Yeah, sorry. Say.
no, you may
Proceed,
continue.
proceed.
But Your Lordship, a compelling public interest is also regarded as the restriction on privacy, which is there in the present case. The compelling public interest to report the matters to the citizens of the country so that they can form an informed opinion. And
Wasn't that an advertisement? That's the reason I asked that particular first question. Wasn't this an advertisement?
no,
The
Your Lordship,
so-called
it was
public
not.
importance was just an advertisement saying that you were able to save a fetus because of the latest technology, which is not even approved by any of the committees. What else was that? Where is the public importance there? It's commercial speech, not even regulated under 19(1)(a).
The council would beg to differ that no, it was not commercial in nature, because the facts are silent as to whether it was done in some commercial interest, and no, it was not in furtherance of advertising the technology, because it is not as if this particular hospital only had the prerogative over this technology.
Sorry, last point.
Sorry, Your Lordship.
What was the
Pardon?
last point?
It is not as if the hospital in the present case only had the authority to control this technology. Even other entities can develop the same type of technology.
Okay. Ever heard of the X versus Z case?
Yes, Your Lordship, about
The Apollo Hospital case. That's the hospital said. Septemiotomo something was X. Is there anything that you have from that particular judgment to support your case? Or does it go in favor of the petitioners?
Your Lordship, to confirm, is it the case where the hospital divulged the information that the person concerned was suffering from AIDS, and this
Not
information
AIDS, HIV positive, yes.
and I'm sorry, and this information was divulged to his partner?
Yes.
Yes, indeed, Your Lordship. Even in that case, it was held that that information which is divulged in compelling public interest is not hit by right to privacy.
So there should be a
Yes.
strong countervailing interest.
Exactly.
Indeed, Your Lordship.
And what was that public interest involved in there? Saving the life of a particular person
First.
or persons. Here,
it is the duty of the journalist to inform the
what's
matters
the
to the public.
what's the huge public interest involved? Similar to that
But
was
Your
there in X versus
Lordship,
Z.
but Your Lordship, even the fact that information of some private nature was divulged is not confirmed. If we refer to the fact sheet, it just says that detailed information about the situation was being telecasted. It is not certain that maybe the name or what kind of private details were divulged. It is not certain in the present case.
So what all could be detailed coverage of the facts according to you? If not this,
Maybe about the artificial womb technology, how it is used, uh, what are its implications.
See, why don't we direct an investigation by the state police chief into the publications that you've done, the PNB News, which is a state-owned media, and if found guilty, let the police take action against the owners of the PNB, not the owners, the person in charge of the PNB News. Are you okay with that?
I would plead that the facts are not clear in that regard.
No, I'm saying you're before the court. We can order an investigation to be conducted because you're saying that essentially it's a question of fact. We'll order a criminal investigation to be conducted by the state police chief. Let the state police chief find out whether there is any private matters published by your news agency. If so, let the person responsible be arrested and a crime be registered against him.
If I may know under which section?
156.3 CRPC.
No, under which for which offense?
So that is for the police to investigate. Would you be okay with that? You being the state, you shouldn't be, you shouldn't have any issues with this.
To that question, I would humbly submit that indeed only the detailed information about the use of this technology was divulged by the PNB News Agency, and no information related to private affairs or say private details of Miss Y were divulged.
And you would welcome
And
any
even
investigation to confirm this.
Did you feel like reading a story when you read this thing? Because the first 3 pages, it's about a story, right? It's about a story of a couple. Agree or disagree?
The first 3 pages, yes.
It's a story. Now, I'll read the 9th paragraph again. Mass media reported the story.
But your lordship, in that case,
you said you considered the point. It was a story. When you read it, the first 2.5 pages, that was a story.
Your lordship, the first one.
Story of why husband X over the husband, yes, and the fetus. It was a story, correct?
No, your lordship, it was not entirely about the couple and the fetus. The Moot shop extensively covered extensively covered the information regarding the artificial womb technology.
Correct. It was not just about story; it was also about information.
Indeed, your lordship.
And paragraph 9 use both these words. Story was given, information was also given. Both the terminologies are used.
But before, if I may bring to your attention, the line just above that states that the case garnered significant media attention as it was the first instance where artificial womb technology was used in the Republic of Samra to save a fetus. Then maybe it can be implied that only the factual instances related.
Right.
That part of the story was reported.
Yes, yes, Your Lordship.
All right. Proceed. 1, 3, and 5. Correct.
You can move on to 5.
1 through 5, yeah.
Your Lordship, it is also to be noted that the paragraph 4 of the Moot prop, it states that there were a lot of infertile couples present in the country, and therefore, even in their interest, the PNB News Agency can have said to broadcasted the information.
Public importance. Okay.
You can move on to the 5th issue.
I will be addressing the 4th submission on the same issue, or if your
you can move
lordship
on to the
want
next
me, I
issue
can.
because you don't have time.
Pardon your lordship.
You can move on to the next issue because you're short on time.
Indeed, your lordship.
Time is
Whether-
already up.
submitting my arguments for the fourth issue, whether the petitioner can invoke a private law remedy simultaneously with the public law remedy. Before beginning with my submission, it is pertinent to note that apart from the writ petition that is filed before this honorable bench, the petitioner has also approached the State Consumer Commission to claim compensation for deficiency of service and medical negligence. It is humbly submitted that based on the Roman maxim, nemo debet vixeri, pro una et idiom causa, the respondent should not be vexed twice for the same cause of action. Further, in Kumud Kumar versus Central Bank of India, the
That's the
Honorable
criminal law general principle, right? 20 clause 2.
no, Your Lordship, it is also a principle of civil law as well.
Really? Okay.
Res ju- Under the principle of res judicata or
Rest
res
judicate.
judicis.
Rest sub judice.
Trust subject. Trust.
So, but is the cause of action same?
Your Lordship, as far as the fifth issue, which is about the uh, clinical trial regulation violation is concerned, and the
No, the private remedy
complaint
that they've chosen is the State
and the consumer.
Consumer Commission, right?
Yes, Your
Why
Lordship,
did
I
they
was coming
file
to
a complaint before the State Commission?
because allegedly there was deficiency of service.
Deficiency of service. Here, they've sought a relief against you, saying that you have violated their privacy. So the cause of action is different.
Your Lordship, but the petitioner, though alleges medical negligence and deficiency in services before the State Consumer Commission, but another petition has been filed on the grounds that respondents failed to obtain informed consent, and therefore it constitutes a violation of the drugs and cosmetics rules. And cause of action for both these petitions are similar.
Wait, where do you get that? Without conducting proper clinical trial, that is a different issue.
Uh, Your Lordship, it is submitted that the cause of action or the factual situation remains the same, that the consent was essentially not taken in both the cases. And the transfer of the fetus was allegedly unauthorized.
See, where from the issues that are framed in the Moot proposition, can you where is it stated that consent is an aspect of issue number 5?
Your Lordship, because
Maybe issue number 2, but not issue number 5.
just but Your Lordship, under drugs and cosmetic rules and the ICMR guidelines, it is essential that before performing such a trial, the consent of the concerned person must be taken.
See,
And
maybe the intention of issue number 5 is for a direction so that such techniques are not used in the future to avoid such mishappenings in the future. That is the intention behind issue number 5. The case which is filed before the State Commission is seeking compensation for the damages that you've caused. So the cause of action and the relief sought are entirely different.
but Your Lordship, it is more or less connected to the taking of the informed consent, because
Maybe one of the relevant issues guiding both litigations might be the same, but the end result that the petitioner is seeking from both the litigations are different. So then the principles of res sub judice would never apply.
indeed, Your Lordship, uh, but the uh, but the final outcome of the present judgment has implications there as well, and
Which is why
therefore,
we've stayed the operation, right? We've stayed the operation of the State Commission, the case before the State Commission, so that let this decision come first.
but Your Lordship, if it is, if as the final outcome it is decided that the informed consent was not even necessary given the emergency situation, then it will
You can
equally
use it
affect.
in for your benefit before the commission. You can get the case there dismissed. Why do you fear the High Court?
Your Lordship, Your Lordship, we don't fear the High Court. It is just the fact that the respondent should not be vexed twice for the same cause of action, because more or less the factual situation remains the same and one will have implications over the other.
Okay.
If your lordship has no further queries, I would now like to invite my co-counsel to present submissions on the remaining issues. It was an honor arguing before the honorable bench.
Courtroom manager, managers, what was the total time that petitioners had taken? Total time that they had taken?
The TL15, the time split was actually 25 minutes for the speaker one, but it's been more than that. It's been 45 minutes.
So
For the
total time taken by petitioners,
petitioner
both
side.
of them
Total
together.
time. Let me check.
Yeah, faster. So allow the same time for the respondents, the total time, not even a minute
Yes,
more.
sir.
You may start, respondent.
Am I both audible and visible to the honorable bench?
Yes, yes.
Much obliged, Your Lordship.
You're not
Greetings,
visible.
Your... Am I not visible?
Surana. Yes, now. Yes, yes, yes.
Greetings, Your Lordship. My name is Meenal Gupta and I'm the co-counsel appearing for the respondent in the present case. In the next 16 minutes, I will contend with issue 2 and issue 5. Firstly, I will address issue 2 and submit that the transfer of the fetus to an artificial womb without the consent of Miss Y does not amount to grave mental injury under the MTP Act. Then I would proceed to issue 5 and submit that the transfer of Y's fetus to an artificial womb without conducting proper clinical trials is not violative of the drugs and cosmetic rules and other laws. If the council may begin with the submissions. Much
Yes.
obliged, Your Lordships. Beginning with issue 2, the Council would like to submit this issue in two prongs. Firstly, the transfer of the fetus in emergency circumstances does not qualify as grave mental injury under the MTP Act, and secondly, fetal viability takes precedence over mental health of the pregnant women under the MTP Act. Beginning with the first sub-argument of the first prong, Your Lordships, it is humbly submitted that indeed there is a requirement for taking informed consent of the patient or his family members by the physician. However, this requirement can be bypassed during emergency situations where a seriously injured patient is brought to the hospital. And in such situations, doctors need to administer treatment immediately without waiting for the consent of the patient or any accompanying person. A similar situation arose before the Honorable Supreme Court in the year 1989 in the case of Parmanand Katara, wherein it was held that in emergency cases, doctors have an absolute duty to attend the patient, and this duty overrides any procedural laws that may interfere with the discharge of this obligation. Furthermore, the Law Commission of India, in its 201st report titled Emergency Medical Care to the Victims of Accidents and Women Under Labor, has pointed out that it shall be the duty of every hospital to immediately attend every person brought to the hospital in emergency conditions without waiting for any formalities. Your Lordships, in the present matter, the transfer of Miss Y's fetus to an artificial womb without informing Y or her family was done in emergency circumstances to save the life of the fetus. The Council would now like to draw your attention towards page number 2 of the Moot proposition, paragraph number 7, line 4. Your Lordships, it has been stated that when Miss Y was 18 weeks pregnant, she suffered an unexpected fall, resulting in distress to her fetus. Further, as per line 7 of the same paragraph, immediate intervention was necessary to save the life of the fetus. Additionally, it has to be noted that after the intervention, the fetus was reported to be stable. Therefore, Your Lordships, owing to the
What's the
emergency
statement
situation,
after that?
sorry, Your Lordship,
What's the statement after that? What's the first part of the eighth paragraph?
Your Lordship, this I would address this in my upcoming submissions. I'm going to address the requirement of consent.
So what
And
are
to
you
answer,
admitting?
And to answer that, your lordships, as the council just stated, in the case of Permanent Katara versus Union of India, a two-judge bench of the Honorable Supreme Court clearly held that in emergency circumstances, doctors have an absolute duty to attend the patient, and this
Paramananda
duty.
Katara was a landmark judgment which changed the scenario in India where an FIR had to be registered, police had to be informed before the hospital authorities could do a particular procedure. So that is okay. That is a ratio for the purpose of that particular judgment. That cannot be brought in this particular context. Moreover,
uh,
what you did per se was a violation of 7.16 of Code of Medical Ethics Regulations 2002. Informed consent had to be taken from the patient. If not from the patient, the husband. If not from the husband, next kin, next relative. And if you were doing an IVF, in this case, when you transplanted the particular fetus to the womb, the AWT, it was some kind of an AI procedure or an IVF procedure, correct? An ART procedure. Again, 7.2.1, the same code specifically says it shall be undertaken only with the informed consent of the female patient and her spouse. Spouse was there. So multiple violations of the regulations by which you are bound. Before
uh,
you continue, before you respond to the questions, Anena, 1 hour 7 minutes they have taken, correct?
Yes, sir. Yes, sir.
And respondents have taken how much till now?
Response speaker 1 has taken 44 minutes.
So the remaining time should be allotted to
Is 25 minutes.
25 minutes or possibly 20 minutes now is all that you have. Yes.
Yes, sir.
Your lordship, to answer your question, I would like to specifically, if I may request the permission of your lordship to kindly allow my researcher to share the judgment of Permanent Katara, the specific paragraph which I'm going to address.
You can state the relevant portion.
Your Lordship, in the case of Permanent Katara versus Union of India, the Honorable Supreme Court has verbatim stated that in emergency cases, doctors have an absolute duty to attend the patient, and this duty overrides any procedural laws. Your Lordship, the keyword here is any procedural laws
Such as,
that. Yes, Your Lordship.
such as, what's the procedural laws?
Your Lordship, the procedural laws can here that can be taken would be the regulations, the code of ethics, regulations, and
That was CRPC procedures. And changes happened in CRPC post Paramananda Katara's judgment. You don't have to inform the police. That was what Paramananda Katara is all about. So even if you show the compendium, the part, that my opinion is not going to change.
But still, your lordship, our stance is that since the situation was a case of emergency, and as doctors, we were bound by our Hippocratic oath. So we were bound to save the life of the fetus, if that satisfies your
What's the
question.
Hippocratic oath?
Your lordship, it is an oath which doctors take upon entering the profession that they would, with their utmost duty and care to the profession, they would protect the lives of the patients that are brought to them, and they would not be negligent in their duty.
Okay. Continue.
Uh, your lordship, if your lordship does not have any further questions with regard to this submission, the council would request to proceed to the second sub argument.
I might have, but not now. Continue.
Sure, Your Lordship. Coming to the second sub argument, Your Lordships, it is humbly submitted that the interests of the fetus must be balanced with the mental health of the pregnant women. Your Lordships, my learned friend from the side of petitioner cited Section 3, subsection 2 of the MTP Act, stating that Miss Y should be allowed termination of a pregnancy as it is causing grave injury to her mental health. However, your lordships, the council would like to highlight that a similarly worded provision exists in the UK's Abortion Act of 1967. If your lordships permit, my researcher would like to show you the
Okay.
section.
Yes.
Y- Section 1, subsection 1, clause B of the UK's Abortion Act 1967. Your lordship, the council would like to would like you to see section 1, subsection 1, clause B.
Hmm.
Your Lordship, the provision is exactly similar worded as to what that is found in India's MTP Act.
Correct.
Furthermore, Your Lordship, the Council would now like to direct you towards paragraph 29 of the written submission on behalf
Can
of
you
the
also take me to
respondents.
clause 2 of the UK Act? Roll down to the next page, please.
Uh,
You don't have the next page. Okay.
Your Lordship, the provision was exactly similar as
No, but
that
you
is
see, in
enunciated.
determining whether the continuance of pregnancy would involve such risk of injury to health as mentioned in para A to B or so and so. So it is the continuation of the determination process which is not available. Okay, whatever.
Uh, Your Lordship, as per
What is
para.
let's look at the UK Act. Under the Indian Act, is there a threshold provided for what would constitute a grave injury to the mental health of a woman?
Uh, Your Lordship, under the Indian MTP Act, there is no particular threshold that has been
But is there any
provided.
indication? Is there any indication?
Indeed, Your Lordship, the indication that is there is that uh, there is a certain gestational age limit that is provided, and secondly, section 3,
Why
subsection
don't
3
you go
states.
through explanations 1 and 2? Explanations 1 and 2 give an indication as to what would constitute a grave injury to a woman's mental health. Explanation 1 would be relevant. Explanation 1 would be the starting point. Let's consider explanation 1 to be the starting point and explanation 2 to be the most extreme point. So
Your
explanation 1
Lordship,
says that if where a pregnancy is alleged, where a pregnancy occurs as a result of a failure of any device or a method used by a woman or a partner for the purpose of limiting her children or preventing pregnancy, the anguish caused by such pregnancy may be presumed to constitute a grave injury. So, reading along those lines, wouldn't the facts of this particular case also shouldn't that the facts of this case also be presumed to cause mental injury to the pregnant woman?
Your Lordship, explanation 1 talks about talks about pregnancies which occur as a result of failure of any device or
Correct.
method used by the women or her partner for limiting the number of children.
Correct.
However, this explanation is not applicable to the present
It's not
case.
applicable. It is not applicable. I'm saying that it is an indication as to what would constitute a grave mental health emergency, whatever, grave injury to the mental health of a woman. So let's assume that this is the starting point, and the ending point being explanation 2, where the pregnancy has been caused by rape. So that is the most extreme, event contemplated by the statute, and the first one being the most lesser or the starting point.
Uh,
Couldn't you equate the facts of this case to fall within this bracket?
Your Lordship, the facts of this case would not be applicable to the bracket that has been provided by explanation 1 and 2, and that was what I was going to submit. If I am audible,
Yes, yes.
that was what I was going to submit when I referred the bench to the UK's Abortion Act. I wanted to take the bench to the House of Lords debates that happened when this Abortion Act of 1967 was enacted. Your Lordship, the Act is of 1967 and India's MTP Act is of 1971. So I would like to state that in during one of the House of Lords debates, and this has been in our written submissions as well, it's paragraph 29 of the written submission on behalf of the respondents. During the House of Lords debates, Lord Justice Chancellor stipulated that the terms grave and permanent that are used in the section are deliberately used to create a stiff legal test. And Lord Justice Chancellor, in fact, gave certain examples as to what would amount to a stiff legal test. He stated that activities such as permanent kidney, permanent brain, or possible heart damage would be a few examples of the situations that can be taken under the expression grave or permanent. Further, Lord Justice Mackay, am I audible to the bench?
You are, you can continue.
I'm facing certain network issues. Further, Lord Justice Mackay remarked that later in the pregnancy, the method of termination has to be selected in the best interests of the women, but the intention would be to deliver a living baby wherever possible. Your Lordship, the Council would now like to take you towards page number 3, paragraph number 11 of the Moot proposition.
See, again, that is the distinction between the UK Act and the Indian Act. The Indian Act does not prefer that the child is born. The Indian Act gives precedence to the mental health of the pregnant woman, which is why the bar is set so low. Even an unplanned
Uh,
pregnancy is something that can be terminated.
Your Lordship, the Council would like to differ at this point. Uh, Your Lordship, indeed, that there is some autonomy that is given to the pregnant women, but that is given only during the early stages of the
No,
pregnancy
this is before
till the
24 weeks.
till the time, Your Lordship, the period of 24 weeks is there to state that it is the time where the fetus achieves viability. And Your Lordship, in the present case, when the fetus was transferred to an artificial womb, the period of viability was preponed. And medical researchers such as Elizabeth Clore Romanis, who's an UK scholar and a professor at Durham Law School,
Yeah,
she teaches
unfortunately,
medical.
you're arguing your case in India or wherever this is, not in UK. Forget about UK. Come to
Your
India. Come
Lordship,
back. Come back to our
viability is a
country.
medical concept. It is not a legal concept. Even the
See,
World Health
the viability
Organization.
discussed there would be in relevance to the act and rules
No,
applicable in
no,
that
Your
particular.
Lordship.
No, no.
No. So, uh, Elizabeth Cloromanis she has done a lot of research on the concept of artificial womb technology, and we have cited a few of her papers in our memorial as well. If you can, the council would like to direct you towards paragraph 36 of the written submission on behalf
What
of
is the
the
point that you're trying
respondent.
to make?
Your Lordship, the point that we are trying to make is that indeed there is some autonomy that is given to the women, but that is perhaps during the early stages of
No,
pregnancy when
why
the
do you
fetus
say
was
that?
not
Because
reach
clause B
viability.
talks about, no, clause B of section 3, clause 2, subclause B says where the length of pregnancy exceeds 20 weeks but does not exceed 24 weeks, which is applicable in this case as well.
Your Lordship, I would like to differ that why would I like to differ is that the concept of viability is a technological evolving concept, and it is
You're
not
saying that
that.
the act should be replaced. You're arguing against the act.
No, I'm not arguing against the act. I'm saying the period of 24 weeks that is apprehended by the Indian MTP Act. When the act was drafted. It was not taken into consideration that technologies like AWT could develop in the possible future, and therefore the period there that is mentioned there is of
AWT has
24
not
weeks.
developed even here. AWT has not been approved.
Your Lordships, you're not audible.
I'm saying that AWT has not been approved here also. It is not in existence. It is something that you've done on your own volition.
Your Lordship, but as per the facts of the case, since we have to assume that India's MTP Act has to apply to the present case, so we have to assume that the gestational limit that is given under this MTP Act of 24 weeks can be necessarily changed depending on the concept of viability, because our case is a factual scenario. So we have to presume that
Do you
the
have
act.
any case laws where the gestational period has been extended or it has been reduced?
Your Lordship, there's a UK judgment of Cleveland versus Municipality of Anchorage.
Council, are you actually under the impression that the MTP Act, as it originally stood in 1971, had this period of 20 weeks and 24 weeks?
No, Your Lordship. I am under the impression of what the Act is in its current form. That is,
What was the earlier form?
earlier it was 18 weeks and 20 weeks.
It was 12
When was
weeks
it
and 20
subsequently?
weeks.
12 weeks and 20 weeks.
Now it has
Pardon me.
been changed to 20 and 24
20 and
weeks.
24. And that is because of
When
the.
was the amendment carried out?
Your Lordship, I think the latest amendment, as per the Act, was done in the year 2021.
So the legislature, in its wisdom, has decided to amend the act after considering all the technologies which are available. Now you're arguing against the provisions of the act itself.
Your Lordship, the Council would again beg to differ. The the act was last amended in 2021. We are now in 2025, and even in the real world parlance, the this technology of artificial womb technology is being tested is now being tested in animals such as goats, and the research was carried out in Netherlands, and it showed promising results.
According to the factual situation, the AWT is a form of ART, correct?
Yes, Your Lordship.
When you talk about ART, do you transplant for the purpose of ART? Do you transplant babies or do you transplant fetuses?
Your Lordship, if your question is with respect to the Assisted Reproductive Technology Act, I would like to seek a clarification here.
It's
Is your
regarding
question
ART, yes.
the act or just ART?
Act.
Again, Your Lordship, ART Act is not applicable in the present case because
Why?
in
Because
case
is it because this particular procedure is not ART?
because Section 2, which defines assisted reproductive technology in the ART Act, it states that assisted reproductive technology is a form of technology in which the zygote or the embryo is formed outside the body of the female by
Exactly.
clinical interventions, and then that is
Exactly,
transplanted
exactly. So are we
into the
talking
body.
about, so now you're coming to the point where we are not talking about ART anymore.
No,
And the
no.
fact says this is nothing but ART. So are we talking about a scenario where there is no law surrounding this thing? Because of which you're referring to the UK Abortion Act and Indian MTP Act.
Your Lordship, we are arguing that MTP Act is not applicable to the present case, and that's
ART
why.
Act? ART Act?
No, Your
Not
Lordship.
applicable.
Even I
No
just
laws are
stated you
applicable.
the definition of ART, and that is why it's not applicable in the
Not
present
applicable. So
case.
which is the legislation that is applicable for us to test?
Your Lordship, we can go by constitutional principles, as my co-counsel just stated, the various constitutional principles.
Did your
To
co-counsel state too many constitutional principles?
She stated certain rights with respect to bodily autonomy, decisional autonomy. I think if the court in the best
Those were
interest,
constitutional principles. Okay.
the rights that are enunciated in various they're a subset of the fundamental rights,
You
like
have
in case of the
mother,
article.
you have a child or fetus. There should be some law that is applicable in this particular context. Why ousting MTP altogether? 5 minutes left.
Because,
Faster.
because your lordship, since the fetus is now viable, the state now has a compelling interest to save its life.
And there is a
And
procedure that the Bombay High Court has said.
but
Take care of
your
the child.
lordship,
Why do you want the particular mother who has said that she doesn't want the child to take care of the child? Abortion at
you
the end of the day means what?
termination of pregnancy,
Which, or in other words, mother opting out from
the
claiming
responsibilities of
any
the child.
particular biological rights over the particular child. Let the state take over. And I did tell you about the Bombay High Court judgment, parents patria doctrine. She doesn't want the child.
But still, your lordship, again, I would cite a Supreme Court judgment here. That there's a three-judge bench decision of
What's
Supreme Court.
pregnancy? What's pregnancy? Pregnancy is over a 40 week, if I'm right. Right?
Hmm.
It's at the 39, it's a 40 week. That's how it's been defined. So the word pregnancy, everywhere that comes under the MTP, it means what? It means a 40-week period. And the child right now is still in the mother's womb. It's just that instead of the mother's womb, it is in the artificial womb, an extension of self. So that could be covered under what? That could be covered under the term pregnancy. And if you remember what your opponents had argued or contended from the very beginning, those were all interpretation techniques and interpretation principles. Principles of interpretation, purposive interpretation, mischief rule. Why do you have MTP at the end of the day? What's the purpose?
Uh, your lordship, again, the council would like to beg to differ. Firstly, because the MTP Act itself doesn't states that it will cover such technologies. So the learned counsel for the petitioners cannot ask for termination under the basis of this act.
See,
And secondly,
can
your
I
lordship,
put it another way? Let's say, for example, two persons opt for AWT technology. Okay. After a while, they decide not to for various reasons. Let's say a grave reason is there, but because of which they decide not to proceed with the AWT technology. The child is already in the womb. Are you saying that there is no option to terminate the pregnancy if AWT is adopted? Because ART
Uh,
Act is not applicable, MTP Act is not applicable, so there is no provision to terminate the pregnancy. The
Your
child
Lordship,
has to be born. If you opt for AWT, the child will be born.
Your Lordship, the whole concept behind AWT, as my co-counsel also just stated, which has been mentioned in the fact sheet as well, that the main objective behind artificial womb technology is to eliminate potential risks or complications associated with pregnancy and childbirth. This is the ultimate motive that is
That is not
behind
the question.
introduction of
Answer the
artificial womb
question. What is the
technology.
question? How can you terminate a pregnancy opted through AWT? Is there a
Uh,
procedure?
your Lordship, then it would depend on the opinion of the medical board. What do they
Where?
say if the in case
What law says that the opinion of the medical board? Because you're saying that MTP will not apply. You're saying that ART Act will not apply. Then what act will apply? What law is applicable?
uh, your Lordship,
This
again
is
the
essentially
council.
why AWT was never accepted as a recognized ART or even any other as a recognized technique, even under the drugs and cosmetic rules. You have violated the law. You have compelled the mother to undergo the AWT, the fetus to undergo the AWT technique, and now you are taking away the right of the mother guaranteed under the MTP Act.
And
Can
it's
you say
and
that you have approached the court to speak?
you're completely taking away the provisions of ARP also. That's what you have contended.
ARP also.
Yeah, so you're not talking about any biological element in here, amniotic fluid from some AI technology, right? That is what the client is concerned with. That's what the petitioner is concerned with. It's not the biological child of the particular patient. Correct.
Your Lordship,
Petitioner.
once the fetus was transferred to an artificial womb, there was no continuation of the same pregnancy. If the council would like to submit, instead, because the nurturing of an artificial womb is not similar to the nurturing of a human womb, so we cannot say that
Exactly.
it was the same pregnancy that was being carried out.
Exactly the petitioner's point.
Since it was not the same pregnancy, then Miss Y cannot claim her right over that fetus as well, Your Lordship. Because when the fetus attained viability, now it is the state which has a compelling interest to save the life of that fetus.
So is the state saying that the petitioner is duty bound to maintain the child or own the child as her own, regardless of her interest? Or are you saying that the child should be born and I look after the child? The state will look after the child.
Uh, Your Lordship, can you
I
please
mean,
rephrase your question?
My question is, are you saying that the mother will definitely have to look after the child regardless of her interests? Or are you saying that let the child be born, the state will look after the child?
Your Lordship, the state will look after the child as per the doctrine of parents patriae.
Okay. Okay.
If your Lordship does not have any further questions, the council would like to summarize issue 5 in like 30 seconds.
Faster, and then prayer. You've exceeded the time
Yeah.
right now.
Yeah, sure, Your Lordships. Your Lordships, Rule 3, Sub-Rule 3 of the Drugs and Cosmetics Rules permits inclusion of pregnant women in clinical trials if it is for the benefit of the pregnant women or her fetus. Furthermore, Your Lordships, as per general
Are
medical
you arguing for the
practice,
state or the hospital now?
Your Lordship, we are arguing on behalf of the hospital, Sumantra
Hospital.
Hospital.
Okay.
Yes,
So
Your Lordship.
you're considering the fact that it was a clinical trial. And you subjected a pregnant woman to that, right?
Your Lordship, we submit that we did it under emergency circumstances and
Name
uh,
the procedure. Was it research?
so Your Lordship, it was a clinical trial, but
Excellent.
it was done for the benefit of the fetus as
It
well
was a
as the
clinical
mother.
trial. Okay. Continue. Faster.
Uh, Your Lordship, as already highlighted by us previously as well, that in case of emergency situations, the state-run hospitals are bound to provide medical assistance to the patients, and failure to do so violates right to life guaranteed under Article 21. Therefore, Your Lordship, it is humbly stated that Miss Y's fetus was transferred to an artificial womb under emergency circumstances to save the life of the fetus, which was already in distress. And furthermore, after the procedure, the fetus was reported to be stable. Therefore, Your Lordships, We as doctors did our best to save the life of both the fetus and as well as the mother, which was also in consonance with with our Hippocratic oath. Therefore, we submit that the transfer of wife's fetus to an artificial womb without conducting proper clinical trials is not violative of the drugs and cosmetic rules or any other laws, as it was done under emergency circumstances. The council would now request to
Part
proceed to
of
the
your
prayer.
Hippocratic oath, I was supposed to say this thing before. Part of your Hippocratic oath also says that whatever in connection with my professional practice or not in connection with it, I see or hear in the life of men, which ought not to be spoken of abroad, which your co-counsel said you did breach the confidentiality by speaking it abroad because there was an outweighing public interest. So that was also part of your Hippocratic oath, not to break the confidentiality.
Your
Okay, prayer,
Lordship,
prayer. Hmm.
Your Lordship, as per the latest clarifications that were released, the Moot prop was silent on the fact that who from the hospital released the information to the state-run media agency, and since the information as to who was the whistleblower was not clear, so we cannot directly impute the vicarious
The
liability towards
clarification
the
say that
hospital.
it was the hospital.
It stated that someone from the hospital.
You're vicariously liable.
But your lordship, we are not sure that who from the hospital. It can
Need
be the
not be.
family
Need not
members
be.
of
Need not be. Need
family
not
members
be.
of Miss Y as well.
Okay. This means
Uh,
someone from the hospital.
Only
That's okay.
from the
Prayer.
Therefore, in the light of facts presented, arguments advanced, and authority cited, the counsel for the respondents humbly submit that the Honorable Court of Samrat may be pleased to adjudge and hold that Miss Y cannot demand the termination of a pregnancy under the provisions of the MTP Act, hold that the transfer of the fetus to an artificial womb without the consent of the pregnant women does not amount to grave mental injury under the MTP Act, hold that there is no violation of the privacy and confidentiality of Ms. Y and other stakeholders, hold that the petitioner cannot invoke a private law remedy simultaneously with the public law remedy, and hold that the transfer of the fetus to an artificial womb without conducting proper clinical trials is not violative of the drugs and cosmetic rules or any other laws. It was a pleasure arguing before this bench.
Rebuttal.
With the with the permission of judges, I invite the teams for rebuttal and surrebuttal.
5 points, Max sir.
Indeed.
Five,
Council seeks permission.
5 points, 40 seconds.
Indeed, Your Lordships. Your Lordships, I would like to ask if certain questions that were posed at my co-counsel, he promised to say towards the end. If Your Lordships permit, I would kind of sum it up. If
Five
not, I would
points, 40 seconds.
would that include the questions that were posed at my indeed, Your Lordship. So Your Lordships, building on my co-counsel submissions, firstly I'd just like to clarify clarification sheet question number 7 does actually tell us who the whistleblower is, and the whistleblower is the hospital itself, Your Lordship. There was just that error. The second thing I'd like to clarify is it wasn't the ICMR committee he was referring to, it's the institutional ethics committee of which has been established under the Drugs and Cosmetics Act, Your Lordships. The third thing I'd like to submit is Your Lordships had posed a question as to if there's a penalty. Indeed, Your Lordships, there's a penalty that is under the Drugs and Cosmetics Act. It says if such an experiment without registration is done, 5 crores of 1 lakh rupees and 5 years of imprisonment will be penalized for. Your Lordships had also put forth a question on the Consumer Court's pecuniary jurisdiction. Your Lordship is actually correct. 50 lakhs for district commission, 50 to 2 crores for the state commission, and more than 2 crores for the national commission. But Your Lordships, the council would like to submit that the facts of the fact sheet is what has committed us to stick to 5 crores. So we don't have anything to directly intervene and say. But indeed,
Should have asked for clarification. You didn't.
Your Lordship?
Should have asked for clarification, which you did not. The other problem is that now the other problem is if this has happened before 2021, all
Indeed,
the other arguments will be spoiled because 2021 amendments to the MTP, everything will be affected. Just that. Okay, faster, rebuttals.
Indeed, Your Lordship. Now, starting off with my rebuttals, the first rebuttal is that the respondent claims that the fetus in the artificial womb is viable and has independent rights, Your Lordship, meaning it cannot be terminated. That is what their contention is. But, Your Lordships, if viability is an artificial womb, meaning forced parenthood for the biological mother, wouldn't this create a precedent where the women would lose her reproductive rights when the artificial gestation is possible in the future, Your Lordships? That is the first humble rebuttal. The second second rebuttal I'd like to put forth is the respondents also argued that the public interest will outweigh privacy. But your lordship, in the Puttaswamy judgment, they have shed light on the proportionality test, your lordship, where the public interest can actually override a private interest. Here, in this case, drawing parallel to our case, if the consent is mandatory for terminating a pregnancy, then the consent should also be taken for continuing the pregnancy, your lordship. That is what is humbly submitted. The third rebuttal that I'll proceed on to is the learned counsels had taken refuge under Article 19 for disseminating the freedom of speech, for disseminating information under freedom of speech and expression. Your lordships, these are the reasonable restrictions: sovereignty and integrity of India, security of the state, friendly relations with foreign states, public order, decency, morality, contempt of court, defamation, incitement to an offense. Your lordships, nowhere in these reasonable restrictions does disseminating an information of a successful surgery account to, which is humbly submitted, which goes in contravention to what the respondents have submitted. Your lordships, the next or the last submission rebuttal that I'd like to put forth is waiver of consent. Your lordships, the waiver of consent can only be done at certain situations, and this has been mentioned under the National Ethics Guidelines for medical and health research involving human participants. VOE, which is the ICMR guidelines. Your lordship, section 11, subsection 7 clearly states that waiver of consent while using anonymized data, researchers should seek the approval of the EC of the institution or the repository for waiver of consent from the donors. So, your lordship, even when a consent, waiver of consent is proceeded with, that also has to be consulted with the ethics committee, which is what is humbly submitted. It was a pleasure arguing.
Surrebuttals. Surrebuttals should be restricted to what the point raised in rebuttal.
Before beginning with my rebuttals, I would like to ask that the questions that were posed to my first speaker, can she answer
Yes,
those questions first?
yes, yes. So she's answering the questions and then you're doing the surrebuttals.
Yes. Or should I answer those questions? It'll be fine both ways.
You can answer the questions.
Definitely, we can't give you the same time the other team got because you're already exceeded the time in your arguments.
Your lordship, as far as the judgment you asked for decency and morality is concerned, in the case of Ramesh Yashwant Prabhu, this was a case where the court has held that decency or morality as a ground under Article 19, Clause 2, though is not just limited to sexual conformity alone, but the standard for an expression to be hit by this provision or this reasonable restriction is high, because as per the courts, it should include something which is shocking, disgusting, and revolting. And this is as far as the reply to the debate between privacy and morality is concerned. As far as the learned friends from the side of the representing the petitioners answer to the hospital being held vicariously liable, it is submitted that for hospital, the Sumatra hospital, to be held vicariously liable, uh, the action of the whistleblower should be within the scope of their employment. Here, it is the identity of the whistleblower is not certain. Whether the relationship of employer and employee existed between the whistleblower and the hospital in the first place is not established. No. Further, if such acts of the employee are done outside the scope of the employment, then again the employer cannot be held vicariously liable. Uh, my counsel would like to rebut the rest of the rebuttals.
Your time is up.
So we are still left with the time.
You know,
Just
we
a
have
minute,
just
just
two
a minute.
rebuttals to make. Just two
Okay.
rebuttals. Can we?
Yeah.
Your Lordship, firstly, the learned counsel on behalf of the petitioner argued that viability would lead to forced parenthood. However, we'd like to state the judgment of X versus Union of India, wherein a three-judge bench of the Honorable Supreme Court stated that once a fetus becomes viable, then the state has a compelling interest to protect the life of the fetus, because if termination is allowed, then it would amount to feticide, which is a punishable offense under Section 91 of the Bharatiya Nyaya Sanhita. Furthermore, your lordships, the learned council mentioned about the ICMR guidelines for the waiver of consent. The council would like to demonstrate that ICMR guidelines do not attract any penalty. Only the Drugs and Cosmetics Act of 2016 explicitly provide for a penalty for the violation of the rules, whereas the ICMR guidelines do not provide for any penalty, and they are more for medico-legal ethic. They are kind of ethical guidelines. They are not mandatory per se. So their violation would not attract any penalty on the hospital.
Okay.
Thank you.
All right.
All the best.
Thank you, participants. I request the participants to leave the chat room so that the judges can proceed with the score.
Let him go.
Well,
Yes, sir.